expenses to less than 6%. So much so that the program was written about in the Journal of Surgery, one of the leading medical journals, because it was preventing kids from motor vehicle crashes. So, and we also have the very first diversion program, which is something I sought for a long time. Grant was allowed through the district attorney's office because I had an issue with kids who would hit a parent in an argument. And as you know, arrest is mandatory in a domestic, and so these kids would be arrested. So we set up a diversion program where we have a counselor in court meet with the parent and the child and agree to 3 months of intensive services. And when they complete those services, the child is never arraigned and never has a criminal record, because it doesn't make sense to pit a parent against a child. This program has a 95% success rate, as do our other diversion programs. They're available to many kids. Almost all misdemeanors are diverted. Since the juvenile justice law came into effect, we divert many of the misdemeanors in our court through the clerk's office, through Assistant Magistrate Lowre, and through our wonderful clerks and assistant clerks, so that it's pretty rare for us to see anything other than really serious felonies now. Although I will say in Worcester, there's a huge uptick in firearms and shootings cases, and we're dealing with those. And of course, those cases are not diverted. But for the most part, we work really hard to keep kids out of court to prevent the collateral consequences that exist once they have a criminal record.
Can felonies be diverted?
Yes, some felonies are diverted. You have a first offense, and it's a felony because it exceeds the amount, like a malicious destruction of property over 1,200, because a lot of damage is done in a building. We still divert some of these felony cases. It's a first offense. The kid's never been involved with the court. Do we really want to have a criminal record? So we can divert them. The district attorney's office is great in Worcester and will most often agree. But even if they don't agree, now that judges have the authority to divert, what I do, if it's a felony, sometimes with misdemeanors, I refer it to probation for what's called a diversion assessment, and probation looks at the family and the child and whether the child has, any problems in school or has mental health issues, and then they make a recommendation to divert it, and then we divert it and put services in place for that child on the diversion program. And our diversion programs in that respect are hugely successful. These kids rarely come back, and they really escape the collateral consequences of having a juvenile record. This is a priority for our court. It's a priority for Attorney Lowre. It's a priority for our clerk magistrate.
So if they complete whatever requirements are put on them for whatever period of time, at the end of that time, the complaint is dismissed.
But prior to arraignment. So that when a carry record is pulled up, it doesn't even show that the child was arraigned. It's good. We bring the parents into it. We work out these diversion programs with things that these kids can do. And we've had tremendous success. We have an extremely robust diversion programs in our county, and we're lucky enough to have judges who are all in agreement with it, and magistrates and assistant magistrates who fully support it. And many of these cases I never see. A lot of times Attorney Lowre comes out to I sit in Milford one day a week, and that's a pretty busy court, and many times she handles the magistrate hearings there, so I see very few arraignments there as she works out a diversion program, works with the local police who are in agreement with us for diversion programs. It's been very effective. We're really proud of it.
Is it up to a clerk or assistant clerk or a judge as far as who gets diverted?
Well, if it's a show cause hearing, which of course is on misdemeanors, if it's a show cause hearing, it's completely up to the clerk and the assistant clerk magistrate, and the judges are fully supportive of that. We trust our magistrate and our clerk magistrate. We all know how important our diversion programs are, so they can make orders. They say, okay, if you're not in trouble for the next 3 months, or you stay out of trouble and you're not coming back into court, and you do this program, and then especially with our teen ride program, which is now coming back up and running after COVID, the magistrates most of the cases that are referred are never even arraigned and are referred by the clerks to the program. And then we keep track, as we did in order to get the statistics for the doctors to submit it to the Journal of Surgery and Trauma. And they compared our numbers to the number of kids that had been in crashes in Springfield and the diversion rates in Springfield. And the diversion rates in Springfield were, significantly higher, just like ours were before the program. But, having a 5% recidivism rate now for a program like that is, I think, unprecedented. And having a domestic violence diversion program, getting kids services and meeting with the parents and mediation, and never having them have a domestic violence charge on their record, I think, promotes exactly what we need to promote with kids in the Commonwealth.
Yeah, thank you very much. Any questions? Councilor Devaney.
Thank you for calling on a counselor. I want to tell you, this is such an honor to have you here. And I have said this before, sometimes we have a witness and I ask, have you ever seen this nominee in court? Once. You have it all, and you've given us a lot of information. And I know I get a lot of calls that judges in the juvenile court. So I've been asking, I know people are asking, so I'm very pleased, Ms. Nominee. Tell me, what do you think is the greatest strength that this nominee will bring to the court?
Well, as I think, as I mentioned in my remarks, she has a lot of strengths, and one of those strengths is she has just the temperament necessary to be a juvenile court judge. I mean, temperament is really important in juvenile court because you have to connect with kids every day. So one of the things we're seeing a lot now in our court and some of the runaways is that these kids are being sexually exploited while they're on the run or sexually trafficked. I've had kids who have been trafficked to other states as far away as New Mexico who have been on the run in our court. And for us, and with her very wonderful temperament, you have to connect with these kids to get them to trust you so that they're not going to run when they walk out of the court. And so connecting with kids every day is a true strength that she has. And aside from her experience, and as I said, in Worcester, where we have UMass Medical School, just recently, I've done cases on children who have needed heart surgery, brain surgery, tracheostomies. This, medical issues are big in our court. You have to have the kind of experience that she has, having done care and protection cases and worked with children to understand the substituted judgment process. But I would say, as you heard, just the courage it took for her to, come into our court, within days of her husband passing away and dealing with a child that has those medical kinds of issues has given her a perspective. We've had some medical cases in Milford recently, and she and I have talked about just the serious issues that this, for example, one particular child would go through. Her own personal experience with her child is just crucially important to really understanding that. But her temperament is just the kind of temperament you need to sit there and look at a kid and say, tell me what's going on. What's going on at home? Can you talk to me about that? And then to ask the question that we always ask, and that's, you're hearing a lot of stuff about you. Tell me something good. What are you good at? Only to hear kids say, I'm good at music, I'm good at art. It's just an important part of our court that doesn't exist in other courts. And Attorney Lowre clearly has those abilities.
Well, thank you. Your testimony means a lot to me. Thank you for coming.
Thank you so much, as always. I appreciate it. 20 years, so it's a lot of time.
20 years, I voted wholeheartedly, and you've made me proud through the years.
Councilor Devaney.
Mr. Chairman,
Yeah, Councilor Kennedy.
just following up on the diversion thing, there was two things you said that threw me off a little bit. One was you talked about it being if it's a first offense. Why does it have to be a first offense?
Well, it doesn't have to, I'm sorry, it doesn't have to be. I'm saying that's, sometimes we get kids on a felony and it's a first offense. and then we say we're going to divert it. But no, we divert a lot of cases after a first offense, because sometimes you have a kid that has, a record of minor offenses, like.
I'm serious, that's what concerned me. If
Then, oh, no, like, let's say there's a second case of a kid, and it's a property case. It's not like a case where there's like a personal victim, and it's a, break and entering into an abandoned building.
divert gun cases?
Yes, yeah, because we can work with those kids.
The second thing that hit me when you were talking, and I was paying attention, when you talked about clerks diverting them, that they were misdemeanors. They're not all misdemeanors in clerks' hearings.
Right.
You get felonies too.
Right, and the issue with felonies, as I think you know, is that, especially with the recent standing order that came out after the Wallace W. case, I think.
I spent a lot of time in juvenile court, so.
Yeah, well, there was, of course, a case over the last year or two, the Wallace W. case, which by the SJC, under the new juvenile justice legislation interpretation, that results in the automatic dismissal of misdemeanors. So let's say you have a child who's charged with breaking and entering, and there's a felony charge there, and then there's a resisting arrest or a disturbing the peace. The disturbing the peace, for example, will be dismissed under Wallace W. under the interpretation of dismissing certain case types. And then there's the sorry? Yeah, definitely prior to arraignment. And sometimes, and so the case will come in and the prosecutor says, right up front, Judge, we're dismissing the disturbing the peace on Wallace. And then there's an evaluation. If the child comes back, the court can look back at whether the child has other charges. So let's say there's a felony combined with a misdemeanor. We can divert it, but under the rules, a police officer has to check the box to say that a clerk can divert a felony. Otherwise, a felony cannot be diverted. And
Why is that?
Because that's the.
That makes no sense to me that the police, I have a lot of respect for the police, but it makes no sense to me that they should be able to make that call.
Right. And that's the law. And Judge Frayne, who will testify, he was on the committee that just wrote the rules for judges based on the Wallace W. case. And, he can clarify even more. My reading of the new rules, which I just read yesterday because we just got them this week, it's always been it's always been that the police check the box. One thing our magistrates do, even if they don't check the boxes, they would say to the police officer, is it okay if we divert this? Or is it okay, if we, we'll make the probable cause finding, but we want to divert it and not put it in front of a judge, and the police officers would agree even if they didn't check the box. I'm not sure at this time, Counselor, whether we still have the ability to do that. Judge Frayne, I think, can probably tell you that, but yeah, no, he did a wonderful job of just with the committee. But I think, and I'm pretty sure, just having read the rules once, that it's going to require. I'm not happen to not be in agreement with that, but that's the interpretation of the SJC, that they're going to require the police to check the box and the magistrate.
That makes zero sense to me. Police are witnesses in the case. That's what they are.
Yeah.
Why is a witness making decisions about whether somebody can be diverted, whether it's you know what I mean?
I
call for a clerk, assistant clerk, or a judge.
I happen to agree with you 100%. Because. My goal in my court has always been to keep kids out of court and to divert kids from the court.
I've been in front of a lot of clerks over the years, probably all of them, one point or other. But, and some of them will listen to the police and not defer to them, do what they think is right. And other ones will look at the police and say, what do you want? And they'll defer to them. And that always puzzled me. That's not a neutral arbiter.
Yeah. I don't know if you've ever seen the form. On the report, and the clerks that are here, and Attorney Lowre can say, there's a little box on the top, I'm sure you've seen it because you've been in front of clerks, and that's what we're dealing with. And I think one of my concerns as the new rules come out, and I have to read them again, as I said, this is very recent, But as the committee just released the rules, and it was, the rules have been confirmed by the SJC and approved. But I think my reading of the rules is that it's not giving clerks as much authority to divert these cases. However, what I do want to say is, even if the clerk has to bring the case to arraignment, the juvenile justice legislation allows a judge, which didn't happen before that legislation, to say, I'm going to divert this. And that's what we're doing. So it can come in front of me and I can say, okay, this is in front of me. I get it. It's a felony. We're dismissing the disturbing the peace because it's a misdemeanor and it's the first misdemeanor. So that's off the table. And then I'll say to the prosecutor, do you want to go forward or can we divert this? And many times the prosecutors say, we're okay with diverting this.
But if they say no, we want to go.
If they say no, then what I say is, well, as you know, the juvenile justice legislation law allows me to make that decision, whether you agree with me or not. And I think this case is appropriate for diversion. If I'm not sure about it, then I'll refer it to the probation department and say, can you do a diversion assessment? And they'll do a full assessment and send it back and say, we agree with you, Judge. We think you should divert it. So there are a lot of options. The options are open, even if the interpretation is it's not open in the clerk's office for a felony. If they don't check that box, it's open to me, and it's something I use a lot.
Just makes no sense to me, but thank you.
You're welcome. Thank you very much.
To the Apollo.
Good morning, Judge.
Good morning.
It's good to see you. I just want to thank you for all your advocacy to get this seat filled, because we both know we've been
Thank you so much. We both know we've had lots of
waiting
conversations.
a long time, right? So it's good to see you this morning.
Yeah, thank you so much. I appreciate it. It's good to see you too.
So let me just ask you, you have the power to overrule the police officer that says they're in a disagreement.
Yes, under the juvenile justice legislation.
A neutral and objective clerk cannot.
Correct. At least that's my interpretation of it. I know that the clerks work with them, but my understanding is it's always been that if they check that box, and I think with the new standing orders, and again, I apologize because I just got the standing orders yesterday and read through them, and they're substantial. And I have to say, Judge Frayne and that committee did an amazing job of interpreting complicated, very complicated cases of Wallace and Nick, very complicated. And my understanding from the standing order is that it gives clerks little authority to do that unless they can say to the officer, you know, we're asking to do this. I will say we have an outstanding district attorney's office. So a lot of times the prosecutor will, you know, have talked to the police officer and they'll check that box. But, you know, the thing is, I think most juvenile court judges feel the same way I do. If it comes in front of you, it's important for us to know, who are you? And, you know, what, you know, why, you know, what brings you here, to really look at that and say, you know, I really need to give this kid a chance. I don't want to give this kid a criminal record, because as you know, one of the major problems with kids is then it prevents them from getting college, funding, it prevents them from getting some certain types of scholarships and federal funding to support them on whatever they do, even if it's a vocation. And it also impacts them. If you're a kid and you go to a voc school and you're a plumber, and you know you finish the plumbing and you want to get your license after you do an apprenticeship, that's going to come up, you know. So why should they have to face that? I don't think they should. So
Here's what I'm thinking. Let's assume the Clerk Moran wants to divert somebody and the police officer says, no, I'm against it. And he says, okay, I'm going to divert him anyway. What can the police officer do about that?
you know, I'm not sure. I'm not sure that the police officer would do anything.
Well, not so much they do, but what can they do? I
Well-
would imagine the most they can do is appeal it to a judge.
That's exactly.
So it gets appealed to you, let's say.
You are correct.
You then can say, well, it's now in my lap and I can do it.
Right. You are correct. The finding of the finding of a clerk, the finding that a clerk makes would be appealed to a judge. So, so there are times when there, for example, there's a probable cause finding, the lawyer gets assigned, and the lawyer, not even doing the Benedetto case, not even doing, you know, I'm going to hear this kid be arraigned. No, they can appeal, there's an appeal process that goes to a judge. I've only done those a few times, but you are exactly right, that it absolutely can happen that way. I mean, one thing that would happen is if it came to me and there was an appeal, you know, on the finding of a clerk, you know, I would look at it the same way as I would look at any case, you know, where I would say, it's not a challenge. It may not be a challenge on probable cause, but it's a challenge. There are other challenges. So let's say they challenge probable cause and I'm looking at it saying, no, there's probable cause. But I think this case should be diverted and I'm going to divert it prior to arraignment. I can still do that. So the fact, you know, I think the best thing that happened in the last several years was that the Juvenile Justice Reform Act gave judges a lot more authority to divert cases even when people don't agree. And I think, as some people know, we also have been given a lot of authority to actually hear a probable cause motion under the Umberto H case prior to arraignment, which was huge, because prior to that, kids would have to be arraigned. That would give them a criminal record. And then the Umberto H came down and said, you know what, a judge can hear the issue of probable cause and make a decision that's in the best interest of the child and within the juvenile justice system to hear the motion. I actually hear motions prior to arraignment, which was a huge thing to happen for judges, because otherwise these kids would be arraigned and only then could you hear what is called a de benedetto motion, as you know.
I think it's incredible that a police officer who's invested in the case would be able to overrule a neutral and dispatched clerk. That's incredible.
Right, we agree. At least we have options, though. I have the option to divert it myself, so.
Thank you very much. Appreciate you coming in.
This is ridiculous.
The Honorable Brendan Moran, Clerk Magistrate, Worcester Juvenile Court.
Thank you, Councilor Juvenile. Good morning, councilors. I'd be remiss if I didn't say it's only been about 15 months since I last saw you, and I want to thank you again for giving me the opportunity of a lifetime to become the Clerk Magistrate of the Worcester County Juvenile Court. But we're here today for Clerk Lowre. And in my honest opinion, I don't believe you're going to find a more qualified candidate in the Commonwealth, particularly when you factor in her temperament, legal acumen, and work ethic. While I would hate to lose her as an assistant clerk, she's more than ready to become an Associate Justice of the Juvenile Court. By way of background, I first was introduced to Clerk Lowre back in January 2021 when she interviewed for an assistant clerk's job in my court. Prior to that, I had no knowledge of Attorney Lowre. However, in the interview, she easily separated herself from the other candidates with her engaging personality, clear passion for working in the juvenile court, and her work experience. She was the unanimous candidate of the committee, which included 2 clerk magistrates, a judge, and an office manager. But as you all know, an interview itself is not enough. When I started contacting her collaterals and references, again, the feedback was unanimous. Whether it was a defense attorney, a DCF attorney, a clerk, or a judge, everyone spoke of her hard work, legal knowledge, dedication to her clients, and temperament. Since she started in our office in March 2021, Julie has excelled as her role as Assistant Clerk Magistrate. She has proven to be dependable, hardworking, and has exhibited a consistent willingness to learn all aspects of the court. She is well liked by staff and litigants, and she has quickly adapted to the little quirks that are unique to Worcester County. Her extensive knowledge of the juvenile law and procedure has proven invaluable to both clerks and judges alike. She's compassionate, and she understands the idea that everyone who comes into our court has a story, and it's our job to understand that story in order for us to understand that. She has excellent communication skills, which are on display as she is consistently able to explain complex legal issues to our juvenile litigants. Whether it's assisting with a personnel issue, working with an angry individual, or at the counter dealing with presiding over a emotional magistrate hearing, Julie has always maintained an even keel. Her temperament might be her best attribute, and I know Judge Erskine mentioned that as well, but in my opinion, this council has a lot of nominees who come before you who have the legal knowledge and experience, and I do think temperament oftentimes separates many of the good judges from the great judges, and Julie has exhibited since day one a temperament that will easily translate to the bench. She has spent almost her entire 20 years of legal career in the juvenile court. She understands the barriers our clients and victims face, including socioeconomic issues, mental health issues, and substance abuse. Specific to Worcester County, she understands the challenges that we face post-COVID, particularly the backlog in cases. This is someone who can get on the bench tomorrow and assist us. I mentioned to you 15 months ago that I don't believe anyone in the court, you won't find anyone who cares more about juvenile court, or at least Worcester Juvenile Court, than me. And that's why I'm here today, to support her nomination for the next Associate Justice of the Juvenile Court. And I would ask that you vote in favor of her nomination, and I can't thank you enough for the time.
Thank you very much. Any questions? So you just heard the discussion about.
Yes.
So I know you're a very good clerk, and I know from personal experience, you put a lot of thought into making sure young people do not get a record. So faced with what we just spoke about, how would you handle that?
So I can tell you practically, very rarely am I, so I've been, whether an assistant clerk or clerk magistrate since 2014, so we're 8 years on the job. And I can count probably on one hand how many times I wanted to keep something at the clerk's level and the officer said no. So, and practically speaking, it's a very rare circumstance. Unfortunately, to Councilor Kennedy's question earlier, there is case law on it. I believe it was a Suffolk County case, late 90s, which basically said that the clerk has no discretion if the officer wants to go forward. With that said, can you have an conversation with the officer? Of course. And I have to say, again, my experience is more times than not, they're in agreement to keep it at the clerk's level. They may ask for additional conditions, but very rarely have I found the case where an officer has said, no, we have to go forward on that. Generally speaking, either it's a very severe case or the kid has a record, or this is not the kid's first time. Very rarely, and again, we're talking about assault and batteries, dangerous weapons, we're talking about larcenies, we're talking about vandalism. It's probably the most common one we see in terms of a felony, which people don't realize is a felony. And routinely, the officers do ask for a hearing.
So I guess if I was in your shoes as a clerk, I don't know what you would do, and I won't put you on the spot asking you. If I felt strongly enough that that complaint should be diverted, and he would not check that box, I would say, I'm going to divert it, take an appeal.
And again, I've been appealed once, and that was on a CMVI. But you're right; it would go to a judge. The good thing about that too is if it goes to the judge, and depending on, I assume if the judge issues it, then they're precluded from hearing that case going forward too. So I wish I could tell you what the answer would be, but I've never been in that situation, because I think more times than not, and I think that's where someone like Julie's personality came in, because she has the ability to work with people. And I think a lot of times you could find common ground with the officer. One thing I've done in the past is maybe you keep the felony at the clerk's level and you may issue the misdemeanor. So if the officer is that adamant about going forward, sometimes you could say, okay, if there's a felony and misdemeanor, how about we keep the felony at the clerk's level so the kid, it's not, I usually phrase Jacob Marley with the chains around you for the rest of your life. That's the felony. That's what I've done in the past. And again, a lot of times they've been amendable. And I've dealt with most of the police departments in Worcester County, whether it be in district court or in juvenile. So that's another technique I would use, counsel. Assuming that there's a misdemeanor, maybe say, compromise.
Thank you very much. You do a great job. Keep it up.
Thank you. And thank you again.
The Honorable Brian Frayne, is I pronouncing it right?
Frayne.
Irish name, you told me.
I did, I'm up right now.
Associate Justice of the Lowell Juvenile Court.
Again, good morning, I'm Brian Frayne.
Tell me what you do with that question.
And I'm an Associate Justice of the Middlesex Juvenile Court, and I sit in Lowell. I have not been back to this room since my own hearing back in March of 2020. And I think my hearing may have been one of the last in-person public events before everything shut down. So it's been a challenging 2 years, but it's great to be back and great to see everyone in person again. It is my privilege and honor to come before you today on behalf of Julie Lowre regarding her nomination to the position of Associate Justice of the Massachusetts Juvenile Court. Julie and I became colleagues in the Norfolk County Juvenile Court when Julie began taking cases as a bar advocate back in 2005, 17 years ago. We worked together in Norfolk County until I left in 2020. From her beginning days in the juvenile court, Julie demonstrated that she has the unique skill set to be successful in the juvenile court. I am proud to know Julie both as a trusted friend and a top-level talent of both delinquency and child welfare law. I'm not here today to summarize Julie's impressive resume or qualifications. However, it is very important to stress that Julie has succeeded in so many different roles within the juvenile court. I know you've heard about a lot of them this morning already, but Julie's solo practice covered both juvenile delinquency and care and protections and CRAs. And there aren't that many practitioners that can handle both the delinquency and civil arenas of the juvenile court. And there are even fewer that can do so both at such a top level of skill and expertise as Julie. In addition to all the trial work, Julie also kind of bookended her juvenile court practice by taking juvenile court appeals, working as a GAL, doing revocation hearings for DYS, and she's basically found every way to analyze issues before the juvenile court that one could do as a solo practitioner. And I can tell you that I'm one of many people from the Norfolk County Juvenile Court that could have been invited here today to speak for Julie. As Clerk Moran said, Julie has the type of work ethic and reputation that from their fellow bar advocates to assistant district attorneys to DCF attorneys to probation officers to clerk's office staff to the judges that she prepared for in Norfolk County. Any one of those people would have come here today to talk about how well liked, how hardworking, and how smart and how skillful what Julie was in the juvenile court. And I'm honored to be the one that, got to be here today to kind of, sing her praises to the work that she did as an attorney with me for all those years in Dedham and Quincy. Throughout her years as an attorney, Julie was an incredible asset to her clients. Again, although she had exemplary trial skills, her work as an attorney went far beyond the courtroom. Julie's empathy to her clients' obstacles and commitment to helping them solve their real-life problems is unmatched. In order to have her young clients achieve positive life outcomes, she would also advocate for needed services and supports in the community. Filling the lawyer's role as both litigator and counselor, Julie's always found ways to advocate for her clients to win on two fronts: legal success in the courtroom and then life success outside of the courtroom. In addition to the value to the families that Julie brought during her years in the Norfolk County Juvenile Court, she was also a huge asset to the court and the court community. I also had the privilege of serving with Julie on the Norfolk County Bench Bar Committee for several years. And through this work, Julie, for many years, was the chairperson of that group, and she listened to the concerns of the court and the needs of the bar, and was very giving of her time to solve those problems. If there was a need for a training for the attorneys, Julie would not only organize it, oftentimes she'd be the one presenting the information on a panel and helping train the lawyers. Her commitment to the families of the Commonwealth included enriching the bar. She understood that the better prepared and trained the lawyers were in the county, the better results there would be for children across the board. Julie is that attorney that was always available to share her knowledge and expertise. My practice was primarily civil in nature, focusing on care and protections. But if any one of my clients ever was charged, picked up a criminal case, or at a clerk magistrate's hearing, Julie was always my first call. She was so willing and always generous to help out any of our colleagues. She's the type of person that if any attorney was working on a motion late into the evening and you emailed or texted Julie, she would email you over a memorandum of law or some samples to look at. Julie's also the type of person that after her cases were done for the day, she'd sit in the bench in the Dedham Juvenile Court or in the attorney conference room to make herself available for the new attorneys who may have questions about legal strategy, where to find a form, anything. She was always available to the newer attorneys who were coming in to practice. I think it was important for Julie to make sure that the newer attorneys had a good experience, were set up for success, because she knew how important the practice area was. And also, I think, as many can relate to, Julie was that person that if someone showed up at 2 o'clock on a Friday afternoon to remove a warrant, the court would call Julie, because they know that she would get in her car, she would come down, she would sit with the child, and she would do a great job on short notice. Like me, Julie Lowre is a juvenile court lifer. She has dedicated her practice and her career to the juvenile court, and this dedication will serve her well to become a judge at the juvenile court. She has the specialized experience and qualifications to succeed as a justice in the juvenile court. Her legal practice for 17 years, as well as her last year and a half as assistant clerk, makes her the ideal candidate to be confirmed as a judge and hit the ground running. I can speak from experience, a little over 2 years in, that there's a steep learning curve for new judges. But I know that Julie is certainly equal to the task and will quickly become an excellent judge if confirmed by this council. Selfishly, I asked this council to confirm Julie so I get the opportunity to work alongside one of the best in the juvenile court business again. And more importantly, confirming Julie as the next justice of the juvenile court would be a huge asset to the court. She brings years of experience as both a trial attorney, appellate attorney, legal mentor, guardian ad litem, and assistant clerk magistrate to the bench. But most importantly of all, confirming Julie as a justice of the juvenile court would be an amazing benefit for the family and the children of the Commonwealth of Massachusetts. Thank you very much.
Thank you. Any questions? Councilor
Nice
Day.
to see you.
You as well.
I was thinking, when you came through, you became a judge in the most difficult time in the history of the court, really. How have you managed it? I know you're here for the nominee, but I've got to ask you that.
I will say it was, when I started, I was confirmed in March. And at that point in time, that was back when everyone said, oh, we'll hold off on your start date for a couple of weeks until this dies down. And then, of course, I waited. I started in June of 2020. And I will say that when you join the juvenile court, the 44 other judges immediately reach out, want you to be successful, are so supportive to get you up and running. And everyone was very apologetic about, I can't believe you're just starting, you have to do this over Zoom, you have to do this over the telephone. But for me, I have to say, I didn't know anything different.
No,
So everyone's like, oh, wait till it's like,
That's just a norm.
right. And everyone's like, well, when it's like it used to be, but I didn't know what it was like. So I kind of learned how to do that. So when I started, we were doing stuff on speakerphone, and then it went over to Zoom. So in some ways, it was a good way to, in hindsight, it was actually a good time to train, because it was in between cases, I could turn my Zoom camera off and like text someone a question. It was so it worked out, and now that things have gotten more in person and more back to quote unquote normal.
So it's like the best and the worst of times.
Yes.
So I really appreciate your statement that you have such a knowledge about this nominee. So you really have worked close and really know. And that means so much to me. I don't want someone sitting there that just, barely knows the person. So your testimony means a lot. And thank you for your service.
No, happy to do it. Thank you very much.
Yes, Councilor Duff.
I just want to say thank you for a comment that you made, because I think we forget, because we're all on Zoom now, but when this pandemic first happened and we had to do meetings, we were doing them on the phone. And we actually had to do a hearing on the phone because we didn't have any other way of doing it. We didn't know what was going to happen. And I think I think you just put something into historic perspective that we just lost perspective of. And I appreciate you mentioning that, because I think it's quite important that people understand, when this pandemic hit us, we didn't know what we were in for. We weren't even employing these technologies. Speakerphone was the best we had.
And
Something we knew to use, right?
yes, and my hearing was in person, but my vote was over the telephone. It was like March 8th. It was literally right. I think the building was closing down around us when I was here.
We had to hold one hearing on the speakerphone because the courts are so desperate for personnel, as you know. This seat's been empty for so long, and it's our duty to get these, as soon as we get the nominations, we like to get them filled, because it's not fair to the citizens. But it's also, if we'd left those seats open during the pandemic, it would have been even more catastrophic. And personally, I think the courts did a phenomenal job navigating something that we've never seen nor anticipated. So thanks, for your participation.
No problem.
Getting a participation notice today.
Perfect.
Councilor Paul.
Good morning, thank you. I know if I were to ask the previous witnesses that we don't have enough lawyers practicing in this area in Worcester. Is that consistent with your experience in Norfolk or anywhere else in the Commonwealth?
So I will say Norfolk County seemed to be lucky in the sense that Norfolk, because it was a little bit smaller, there were a lot of attorneys that would do Norfolk County and Plymouth, or Norfolk County and Boston. So that, after I left private practice, I worked for CPCS, and Norfolk County was one of the few counties that never had a problem with getting lawyers to take cases. It seemed to be one of those outlier in that respect, that there was never any, we never had delay hearings. There were always counsel available in Norfolk County. Now that I'm sitting in Middlesex County as a judge, we are seeing that more and more, that it's hard to attract lawyers and it's hard to keep lawyers.
Okay, yeah, that's kind of anecdotally when I talk to people around the state, Norfolk sounds like the exception.
Yes. Yep.
What do you think can be done about it?
I think from my experience, I did a lot of training at CPC of the new lawyers. I was often involved in the training of the new class, and especially, I think the problem usually lied more with the care and protection in the civil side of it. There seemed to be, it was never really a problem to get the bar advocates because there were a lot of adult criminal defense attorneys who would also do juvenile for it. So the real need seemed to be in the care and protection side. And I think one of the things that CPCS has done over the past few years is they've fought really hard to get a better hourly wage for the attorneys, and that's helped some of it. But I think some of it is also, there seems to be a lot of the recent law school graduates are kind of in the Metro Boston area. A lot of the need is out west, Worcester, Springfield, Pittsfield, and so it was very hard to get people to go out that far to work.
Do you know what the trainings are like to get on the care and protection panel?
Yes, and so to get on the care and protection panel, you have to apply. It's a pretty, they have a screening process. We have to, there's a couple essays as why you want to do this work. And then the training itself is usually, I think it's about 2.5 weeks broken up over about a month's period of time, where the first portion is a lot of, lecture and group work. And then the end of that training is they actually host a mock 72-hour hearing, which is the initial custody hearing for children. And they work on that for about a day and a half and have to do a full hearing from start to finish.
And the attorneys aren't compensated for the 2.5 weeks that the training takes on?
No, not the staff attorneys would be, but the bar advocates are not.
Not the bar.
And actually, they have to pay to attend it. So.
Right, they pay to attend and give up more time.
Yes.
To attend. Okay. Thank you very much. Thanks for being here this morning.
No problem. Thank you.
So, the issue of diversion.
Yes.
What's your thoughts on that?
So in Middlesex County, the district attorney's office has a very robust diversion program, and District Attorney Ryan will, anything that she can attempt to divert, she will divert. And so for us, we don't even see that many even come in to the arraignment stage. They come in for the first date. Usually what happens in due course is they'll say, we want to do our own district attorney diversion screening. Can we have a 3-week to a 4-week date just to see if we can come up with a program? And then most times they come back and they've come up with a diversion program for the juvenile. In the cases where they either can't divert or aren't willing to divert, and then I have a similar practice where if someone's moving for judicial diversion under the statute, it'll many times if it's one of those cases where if it's either a felony or a more serious misdemeanor, that's when I will also use the statute as probation to do the 2-week screening to kind of meet with the juvenile, get a sense of. Again, for me, it's not just whether or not to divert, it's once they're diverted, what does that mean? Is it just don't get into trouble for the next 90 days? Or is it what kind of program you're going to do? Because I feel an obligation that not only I think it's wonderful to divert and have juveniles not get a criminal record if we can avoid that. But I think it's also is equally important is to give them the tools and the support to make them not come back. Like, I don't want to see someone, I don't want to have a conversation about should this be diverted a second or third time. I would like to somehow try to get some services in place to try to give these young people the tools to kind of avoid the system altogether.
Many years ago, the juvenile court had jurisdiction over juvenile murder cases. And I think it changed in the early 90s. And I was fortunate enough to have the last juvenile murder case ever tried in Massachusetts with Judge Kantrowitz. And in those days, a guilty on a juvenile murder was punishable by, I think it was 15 years. And a second-degree murder was 12 years. I thought it was a pretty good system, but the times being what they were, with a lot of juveniles committing very serious cases that got a lot of publicity. So the legislature took the power of the juvenile court away from murder cases. Gave them to the Superior Courts. But my opinion of the juvenile system, I go there, I don't go there a lot, but every time I go there, I'm really not amazed, but I'm really inspired by the dedication I see in that court by judges, clerks, probation officers, court officers, all for the protection and help of children. It's really an amazing feeling when you go into that court. I also think it's one of the hardest places to be a defense lawyer or a DA because of all the moving parts you have to go through to, get the case resolved or try the case. So I find it to be one of the hardest cases to have as a juvenile case, in my view. So I take my hat off to those who go there, take all those cases, and everybody in the court. I've never met one person in juvenile court that ever said, this is a lousy job, I hate being here. It's really an inspiration when you go in those juvenile courts. So keep it up, whatever you're doing, your judges and clerks. It's
I'd be happy to.
Thank you.
Thank you.
Okay, no more witnesses for. Any witnesses against? No witnesses against. We will hear from the nominee.
Thank you, Councilor. Good morning again. I'd like to thank Governor Baker and Lieutenant Governor Polito for the nomination to the Juvenile Court. I'm extremely honored to be here today and am humbled by this entire experience. I'd also like to thank you, the Governor's Council, for the opportunity that you're giving me today. And I thank you for the time spent with me prior to today's hearing and your commitment to this process. I'm also thankful to Chief Counsel Bob Ross, Lauren Green, the JNC, and the Joint Bar for their due diligence, dedication, and to the vetting process for this position as well. Thank you also to my witnesses, First Justice Erskine, Judge Brian Frame, and Clerk Magistrate Brendan Moran for taking the time out of your extremely busy schedules to be here today in support of my nomination. And I have to also thank my family, my friends, especially my children who are not here today because they're away on vacation, and my mother, and of course my husband, Michael, who's not physically here as we now know, but is here in spirit. Throughout this process, and rightfully so, the focus has been on my qualifications for this position. I firmly recognize that qualifications of a juvenile court nominee are extremely important. I would not have applied for this position, and nor would I be sitting here today if I did not think I was qualified. But I do hope, in addition to my qualifications and my dedication to the juvenile court, you'll also consider my life experiences, because, after all, those experiences have made me the person I am today. I recognize the massive responsibility a juvenile court judge has, and I fully appreciate how decisions made in the juvenile court have lifelong impact on the people that the court serves. And I especially appreciate those impacts, the impact of those decisions on our most vulnerable population, our children. I strongly believe that a judge not only needs to have a temperament in the knowledge and the law, but also has to be able to be empathetic and compassionate in order to carry out their role successfully.
No, look, in a perfect.
These qualities are qualities that are developed over time, and it's through different life experiences that have been part of my life that have made me who I am today. I would not be sitting here today if it weren't for the unconditional love and support that I've received from my parents, Jesse and Eileen. My father is here today. My mother is kind enough to be away with my children, watching them on a beach today. My parents have been married for over 50 years, and their dedication to each other and to me and my two siblings is beyond admirable. I grew up in Rosendale for quite some time, and then ultimately in West Roxbury. I watched my parents work extensively in order to provide us with a lovely home, and they also provided us with a strong education. My parents taught me that extremely hard work and a strong work ethic and perseverance can pay off. Both of my parents came from humble beginnings. My father was one of 5 children and a second generation from a family that came from Italy. My mother was one of 7 children, and she was first generation of Irish descent. My parents taught me early on how important an education was. I watched my own father, or at least knew about the fact that in order for him to get his education, he had to attend school for 12 years in order to get a degree in electrical engineering. And he went 12 years nights while working full-time. He did this for us, his family. In the meantime, my mother had given up her career at the phone company to stay home and raise me and my siblings. But she worked weekends and nights in order to help continue to provide for us as well and support the expenses related to our private education. In addition to a strong work ethic, my parents have inspired me in so many other ways. They've taught me innumerable life lessons and values. I'd be here for days if I were to try to list all those values and lessons that they've passed on to me. The something on that brings through for my everyday life, first and foremost, is to treat others the way that I want to be treated, to always stay true to myself. They also taught me that sometimes life throws curveballs. And in that same vein, they taught me that it's what you do with those curveballs that counts. And that's what has helped me build character throughout my years, not only in representing children and families in the court, but also on a personal level. That latter life lesson was the one that became absolutely invaluable to me when my daughter got diagnosed with leukemia and my husband 1 year later was diagnosed and then a year later died. As previously indicated, my parents have been married for over 50 years, and their love for each other has always been an inspiration to me. I can say too that I was blessed in meeting my husband. I met him when I was 15 and I was married 9 years later. And he and I spent 30 years together. And I was by his side at the point of his untimely death due to cancer. I don't say this or tell this story to elicit any level of sympathy, but to make abundantly clear that it's these life experiences that have led to me to have a greater awareness and understanding that when you walk into a room and you meet different people, you have no idea the life that they've lived, the crosses that they bear, or what they've been through. Notwithstanding the fact that this was a horrible tragedy for me and my 3 children, Braden, 17, Ryan, 15, and my beautiful daughter, Madeline, 9. They are his legacy, and I feel blessed to have them by my side. Again, I don't say this and tell this story, and I didn't need anyone to die in my family, and I didn't need a diagnosis of leukemia to be very aware of the fact that everyone brings to the table their own personal life experiences. And so I'll use that, and I promise that I'll use that perspective and those life lessons if given the opportunity to be on the bench. Thank you.
Very well done. Would you introduce your father and your best friend?
Sure, will do. Okay. My father is Jesse Downing. He's here today. As I indicated, my mother, Eileen, is in Marshfield, hanging out with my 3 beautiful children. I couldn't rip them away from their vacation. And my dear friend, Liz Bowers, I've known her since I was about 8 or 9, and our relationship started then. I used to babysit her children. It's just very important that I know that she's a palliative care nurse practitioner. And I'm blessed, first and foremost, to have her as a dear friend, but when everything was going on with my husband, I can't tell you the invaluable support and love that she gave me and my family.
Thank you very much. Councilor Devaney, your time starts now.
I'm sorry. I'm getting emotional here. So good to see you. I do want to say publicly that this council times your hearing, and you have from 9:30 to 10:45, 1 hour and 15 minutes. We're having someone come in at 10:45. I've made a motion that we only have 1 hearing, like the councils, but 7 to 1. And now we got about 13 minutes. The other thing is I'm timed because I asked too many questions, so we're gonna be timed. So I first want to say to you that meeting with you was such a pleasure. And I cried then, and you made me cry again. And I have to say that you're an amazing person. You are an amazing lawyer, mother, daughter. I can't say enough. And shortly after you had got this position, your husband died. And I know what that does for you and your children. I've been widowed 22 years, and I know. And I just, you have amazing strength. And I can't, and I usually don't show my hand, but I can't think of anyone more qualified to be on the juvenile court that I have had before me. Juvenile court is especially important to me. And I will not vote for anyone who hasn't dedicated their whole legal career with juveniles. And I had a little experience. I volunteered a year in court with juveniles on probation. It took a while to get their trust. I saw them one-on-one. And it was a great experience for me, my children, to see how juveniles, the sad part of their lives. And I met with a teenage girl whose mother was a prostitute. She didn't know who her father was. I used to lock her in the room when she went out for the night. So I won't go into all of them. So I really understand what it is. And I will not give this as a consolation prize to someone. And you have it all. The thing that impressed me was that not only that, but you have been on chief welfare, juvenile delinquency cases. But the thing is that you have participated in programs, Norfolk County Case Flow Management Team. So you're looking for solutions for these addicted and alcohol and kids that are physically and sexually abused, and to come up with solutions and to be on the juvenile court initiative team. So I want you to talk about that. But I first want you to talk about your writings. You know, it's sad. You know, we grew up with mothers, you know, we trusted our mothers, they were protected, but things have changed and not for the good. Now, I want you to tell us, and so you have great writing skills. Tell us about that unfit mother and tell us about that writing.
Certainly. That was an appellate case where I represented 2 young boys. And the underlying case that was before the trial court, the trial judge terminated the mother's parental rights. And as you're probably aware, the father has a right to appeal it. That case went up on appeal. I represented the 2 children in that case. And the argument before the appellate court, basically, paraphrasing and simplifying a little bit, the argument was that the mom did not actually abuse the children. Because in that particular case, it was numerous boyfriends that had been in and out of her life, and they were abusing the children. So there was this long history of abuse that her children suffered for many years. Mom appealed and was basically arguing that because she didn't conduct the abuse that she should not have had her rights terminated. And there were other supplemental arguments that came in as well that she put forth, but that was basically the crux of the case. One of the little boys that I represented had suffered from, I believe it was 21 fractures to his body, and I think he was only 4 or 5 months old, and he needed surgery to repair one of his leg. So those facts were, you know, obviously it's always excruciating to read them, but my role is to advocate for them and what their position was. And because they were children, I could substitute the judgment. So he was an infant, and I substituted my judgment and put forth the position that the mother's rights should remain terminated and not be overturned.
You know, I wish there was a law to prosecute these mothers who are drug addicted and alcohol addicted, and their babies come into this world suffering and in pain, and for the rest of their lives they have health problems. And you see a lot of those, don't you?
Certainly, yes, a lot of substance.
There's no solution for that, is there?
I wish there were.
But you have worked with indigent people who don't have any means. I love that, and the pro bono. You know, it's just heartbreaking. I don't know how you could do it. I really admire you for going into the juvenile court. I couldn't do it if I had the skill. But we think about a 1-month-old baby. You've had all kinds of cases that have been abused. It's just incredible. And I don't think there's enough punishment. I don't think there's enough punishment for people who abuse children. I really don't. But especially mothers, there's got to be a law to say that when you have ruined this life of this child, you know, that there should be some punishment. But that's my opinion. Tell me about Jerry and Noah. Was it Jeremy and Noah that you had, the 2 boys? And I can't even imagine, even back to 4 months old. So why don't you tell us that?
Counsel, that was the same appellate case. So Jeremy and Noah, they were the ones that suffered the abuse at the hands of many men that were in and out of the home. And the baby was the one who had the 21 fractures and needed surgery. And court held the termination. I'm glad to
You
say.
see a lot of the children, thank God there are grandparents that are able and loving that take them over, like this 1-month-old baby, and you looked into it to see that they thrive.
Oh, yeah.
You get a lot of cases like that.
Yeah, so that case was Sean. It was with regards to Sean, just the first name is what I'll use. Yeah, he was born when I think he was a month old, and there was a domestic dispute in the house, and the baby was found on the bed with needles, hypodermic needles, and the father had overdosed, and so the child was removed from the home, and I was assigned to work with the baby. I believe that if at all possible, when a child is removed, there should always be a kinship. The priority should be a kinship placement with family. And for I don't know, put the baby in with foster family immediately. And so I advocated for him to get to the grandmother as quickly as possible.
Now, tell us about those 2 programs you were in, because I think that adds so much to your ability from before, that you have tried to find solutions to these things.
Certainly. So while I was still practicing in Norfolk, when I was on the bench bar committee, Judge McCallum had asked several attorneys to join at the time it was a case flow management team. And I think it was a precursor to the Pathways Initiative by Chief Nectum. And the ultimate goal was to take a really good look at the care protection cases and what was coming before the court, and whether or not there are ways that each county could find specific ways to try to expedite those cases so that children weren't, forgive the term, but, flopping around in the foster care system for lengths of time that would obviously be contrary to their best interests and not giving them the permanency that they deserve.
And when you work with these indigent clients, I mean, for them to go through the juvenile system, it has to be horrendous for them. So I thank you for all of that. And the other thing is that people don't realize what happens to these children who have been in such horrendous situations, drug addiction, alcohol. And I don't know what the answer to that is. I don't think you have. I don't know. But I know that you're working on programs for solutions, and I thank you for that. I hope you'll continue. I think I wanted to tell you that I talked to Police Chief Carmichael. He couldn't say enough about you, and he did send a letter. And he came from Walpole, but now we've got him in my district. He's in Newton, and we love him. And he just couldn't say enough about you, working with you, and what you have done. So I just wanted to mention that. But, this whole opioid epidemic, it's, the babies addicted, lifelong health issues, mothers abusing their children. Mothers, it breaks my heart. They will allow the boyfriend to be torture, rape, kill their children, and still will support them. You've seen them go to court, and they're going against this man who threw, was that the alcohol? She was burned. There was someone that was burnt, and she blamed herself that she had been smoking or something. It was actually the boyfriend. Yeah.
I think that was within the appellate case as well.
Yeah, I mean,
She had older kids and they had suffered abuse with other men. And the argument before the appeal court, or what I put forth, was that her past actions and this pattern of behaviors is what would allow the judge to uphold the termination of her parental
so
rights.
they go to court against the boyfriend or the husband, and then they reverse their, I don't know how you can deal with them as a judge, but I just, you are the whole person. I just think, and I have been in touch with one of the judges in the juvenile court for the past year, begging. And, people think we have such authority. I wish I could. I wish I could do that. But it isn't that way. We have to wait till that person comes before us. And this has been a long wait, and it was really worth it. And I thank you for the time that you gave me. It was really, I can't tell you, and to have your dad here, I mean, it could be better than that. And your witnesses were great. So, like I said, I don't have a poker face. I've been smiling since I first met you on this, crying a little, but thank you for all your time. And congratulations.
Counselor Duff?
Thank you, Mr. Chair. Really enjoyed my time talking with you. I wasn't planning on talking about some of this addiction stuff, but as one who's worked with addicts in a professional manner and setting, I frankly am very disturbed by what the previous counselor said, and want to go back and Commissioner Colby, talk to you a little bit about your understanding of addiction and how it impacts people and why they do some of the things they do when they're addicted. Just generally, can you share with me, what do you think addiction is? And
When I first started, it was, to me, early on in my early years, addiction was kind of like a black and white. It was just you were addicted. I never looked at it as a medical condition. But over the years, as I work with so many children and families and parents who have suffered from addiction and substance use disorders, my take on it has completely changed. I look at it as more of a medical issue that needs to be treated. I could not answer as to what would be the best way for people to approach it, but I don't think that what we're doing now is working. Because I see the same issues come up over and over again when it comes to substance use disorders. And to just elaborate, I've always been well aware of the fact that addiction isn't just standing on its own and by itself. There's oftentimes mental health issues that precede it, and things that might build up to it. And so there's oftentimes a dual diagnosis and so many other pictures that need to be considered with regards to substance use disorders.
Yeah, the comorbidities are really, in the medical profession, which was the setting that I was in, are often more complicated, just the chicken come before the egg, who knows? When a mother is addicted, she's clearly self-medicating. Blame the mother. Blame on someone for their addiction. I mean, it doesn't absolve them. Let's go. I've held babies in the NICU going through. It's nothing. And we may talk about this. It's an incredibly disturbing yet powerful experience, but I think we need to be clear in this chamber that we can't blame the addict. And it's an addiction. It's a disease. And sometimes the disease causes people to do horrific things. So I really, after hearing what was said, I really feel very strongly that I have to sort of counter it because it's dangerous, in my opinion, to blame an addict for the behavior. It doesn't absolve them of their behavior. Never does. I mean, I'd be curious what the judges and think. But it is a very strong disease. And with opiates, with heroin, you don't take heroin. Heroin takes you. Take it once and just throw up and get sick. I take it twice. The third time you are addicted. I am not a conspiracy theorist by any stretch of the imagination, but what I saw as a chaplain working with opiate addicts 12 years ago, before this was a du jour issue that everyone was suddenly caring about, it was clear to me, because my other expertise was in hospice. So it was clear to me there weren't enough dying people in the world to be making that much OxyContin. It's clear to me that half of the profit was clearly, at least half of it, coming from the street. Your addicts tell you they don't want to go to Florida because it's so easy to get OxyContin down there, because senior citizens are selling it to supplement their incomes. I mean, that is so crazy and upside down, but that is real. No one wakes up in the morning and says, you know what, I think I'm going to become a heroin addict. I think I'm going to get addicted to cocaine, or you know what, I think alcohol is the addiction for me. You know, don't do that. And it's imperative that the judges in the juvenile court, again, it's not absolution. I know that people do horrific, horrible, horrible things, and they need to be held accountable, but they also need to get well. I don't think anyone in this building, or most people in this building, or citizens of the Commonwealth actually have the stomach to invest what it will take for people really to do well. Because I have very strong thoughts about how it should be done, and I don't know if I'm right or not, but I know what we're doing isn't necessarily working. That said, there are programs that are working. The Angel program up in Gloucester, where I'm from, the PARI program, those work well. I think it's Star House up in Salisbury. That's a great facility. You know, I saw my addicts that I worked with know there were certain places they wanted to get to, because they knew if they could get there, they could maybe get better. But we need to be very clear when we talk about this, that the survival rate, the clean survival rate of an opiate addict for life is 15%. 15%. Now, you may be sober for 20 years, but we all can pick up the tabloids and see which, you know, famous person has suddenly overdosed on heroin after 20 years, because the longer you're off it, the more dangerous it is. Anyway, I'm sorry to go on that tune on that. I really need to know that you really get what addiction is.
Do.
And that we can't be blaming mothers because, hey, listen, they didn't get pregnant by themselves. You know, I was raised, you know, in a certain church where they thought that could happen, but I think biology has taught us it doesn't. There are men involved when women are pregnant, and are they being held accountable to the same standards? I mean, this is a huge issue today, right? Because Roe has fallen. And I don't know, do you expect that you will have anything to do with juveniles coming in that might be asking for abortions? I mean, you could possibly be the judge on call, I suppose.
Correct. The juvenile court doesn't have actual jurisdiction over those cases. They're called Mary Moe cases, and
Yes.
a 16-year-old is seeking an abortion and doesn't have parental consent. Those cases go to the Superior Court. A circumstance that could arise where I'd have to deal with that issue is if I am on judicial recall response, and it's something that would need to be decided. I haven't heard of it happening often, but it doesn't mean that it can't happen. So I'm very much aware of the fact that that would be an issue.
Are you able to say to us today that regardless of whatever your personal or religious beliefs are, that you understand the separation of powers and separation of church and state?
Absolutely.
And can make those decisions objectively for what would be the best health for that child.
Without a doubt. Absolutely.
And so will you say to me, I will uphold a woman's right to choose
I will absolutely uphold a woman's right to choose
and the
and
right to have complete autonomy over their body?
the right to have complete autonomy over their body without any doubt or reservation.
Because it's important. And again, since we're on the record, if you can't do that, if you recuse yourself, that's okay. But you can't have it both ways. We're not King Solomon. We're not splitting babies anymore in this country. There is no more settled law. Thank you. Sorry I know I came off kind of stern, but addiction is a real serious issue, and to be victim blaming. The victim sometimes is the addict, even though they've committed the crime. They're a victim themselves. So for people in this chamber to not get that, I find mind-boggling and disturbing, because I've been here 10 years. So I'm sorry, I really felt like I almost had to correct the record, because I think what was said previously was frankly outrageous, absolutely outrageous, and a complete display of ignorance in the real meaning of that word, not in a pejorative way, but in the meaning of the word, of not understanding what this issue is. And this issue will intersect, and probably intersects in your work every single day. Grateful that you are willing to step up and serve the Commonwealth, because you have been through your own, dark night of the soul. And every day, all of you who serve in our juvenile courts and in many of our other courts are seeing this. And it's one of the reasons I also ask, do you have a strong personal and professional and spiritual, and I don't mean religious, I mean people like your friend who hold you up, support system? Because you have and will continue to see horrific things.
I do. I have an extremely strong circle of friends. My family, my children inspire me as well. In addition to that, my community that I live in is unbelievable in ways that way. And then over the years, you learn ways to find ways to cope with the horrific cases and how to handle them.
And for our judges who are here today and our clerk magistrates, I implore you that if you don't have these in place, or even if you do, check in with it. Because we live in a very contentious world today. And there may be a time where you make a decision and it doesn't go how we think it's going to go. A person commits a crime, something horrible happens, a child dies. A child dies. Nothing worse, right? But it's not done with malice. I don't think there's anyone in the court that acts with malice. However, that's not how the world judges you today. And the press is brutal, and social media is brutal. People are brutal. Civility is gone. And I have to check myself, frankly, with some of this stuff, because you get so hot, you get so angry. But I think it's really important that our judges have those things in order for themselves, because you have a very, very difficult job, And I do thank you for stepping up and applying. I know we have adopted a system more like the US Senate. This timing does not come from nowhere. It comes to have some order, and it's worked quite well. So I'm sure I'm coming up on my time, but I'm concluding my comments for now. Thank you, Mr. Chairman.
Thank you very much. Yeah, and just for the record, every counselor has the same amount of time. Councilor DePaul.
Thank you, Counselor. Thank you, Counselor Dunn. Good morning. Everyone I've spoken to about you has wonderful things to say about you. People who reached out to me who I've not connected with yet have also indicated positive things about you. And we've been waiting a long time to get someone in this seat in Worcester. So I don't have any questions beyond that, Mr. Chairman. Thank you.
Thank you, Councilor Hurley.
Yes, good morning.
And a long drive in this morning to get here.
Yeah, just so you know, the FedEx truck broke down on the Massachusetts Turnpike. So instead of going 65, I was going between 0, 10, and 20. from, what the heck is the last, the exit just before where the big mall is? Somebody help me out.
Natick?
Natick. So I was from Natick in until we got past it. It was a really fun trip. I just want to, first of all, say, we talked, and you were one of the easy ones, because I got calls from people, I made some phone calls, and checked with some of the juvenile judges. I'm sorry for your loss. I pray to God that your child is okay. Tough road to hoe, no question about it. I would indicate that I was, before I got here, I was listening, and Judge Erskine's lecture on juvenile court law was just great. When I first started practicing law, I knew the one place I didn't want to be was juvenile court. In Springfield, you'd go in at 9 o'clock, and you were lucky if you got out at 2 or 3 in the afternoon for one case. I'm glad to hear all the reforms. Not that I'm going to go practice in juvenile court, it's not going to happen. But I think you're going to be an incredible judge. It's not what you do the year before you get interviewed for the job. It's what you do every day in every courthouse, with every person, with every lawyer, with everybody in the court personnel. My father taught me a long time ago that it's not the judges that run the show. It's the court officers who can get you a little note to the clerk. It's the assistant clerk who realizes, oh, you've got to be in 3 courts? Okay, I'll help you out. You've done it with everybody, and that shows that you're just a truly good person who has empathy, good judgment, great work ethic, and the temperament that's needed, especially in juvenile court. So I thank you for applying, and I think you're going to do a great job. Thanks very much.
Thank you, Counselor. I appreciate that.
Counselor, I have 3 minutes. Your rule. I just wanted to say, I didn't mention that you've had hundreds of cases as a solo practitioner, and I would be remiss if I didn't mention that all the cases you've had for child welfare, and I think that's very important. So you know, assistant clerk magistrate, right to a judge, and he's a lot. So experience and your compassion and helping people. So the question I wanted to ask is, in private, when we met privately for that long time, I did ask you, do you think that the age should be increased in you did juvenile court?
I do not.
Yeah. Yeah. I mean, what do I know? But I just felt they're overworked now. And to me, I'm concerned the juvenile crime has increased. These mass killings are young people. And so, I mean, what is your, well, you have no solution to it, but do you see that the crime is increasing with juveniles? I mean, serious crimes.
I mean, I've seen it on the news nationally, but I mean, our courts are pretty steady with the amount of cases that come before us. We're really busy doing the public hearings. We're all every single day. Sometimes you have 5, 7, 10 a day. So it's busy. I can't sit here and say that it's increased after business has started. It's pretty steady, and the numbers have remained pretty much the same, at least from my perspective.
I just wanted to put on the record hundreds and hundreds of cases, and I was remiss in not mentioning it. And, you know, I echo my colleague, Councilor Hurley. I couldn't be more happier than we need you. And it's been a long wait. Thank you.
I just want to, I did not hear your response to Councilor Devaney's question about raising the age.
I don't think we should.
Amen. Hallelujah.
So to follow up on that, what's your reasoning on not raising the age?
Part of it is because of how busy we are. The other part of it, in my mind, after working with a lot of kids in DYS, physically in DYS, I worked with kids that were committed to the Department of Youth Services for many years as well. I just raising the age and having, I know it might sound weird, but having that age group also in DYS with other kids, I just think that there's just this fine line with that. And I just think the courts are just so busy as it is. That's really my reasoning why. And
Well,
it should be
it
raised.
seems to me that if it's just because of busyness, then we need the legislature to give us more judges,
Yeah, I mean,
personnel.
I would question whether or not we could give them the services that we provide to them now. I mean,
Let's assume in a perfect world, we could do all of that.
if you could actually do it, then perhaps, but I'm not sure, then where does that line stop? Do you go to 19, 20, 21, 22? Where does it go?
Do you believe in the studies that have been done that show that a juvenile mind, especially a male juvenile, is not fully developed until the age of 25 or 26?
I've read the science on it and I can't dispute it. I think when you're utilizing the science that backs that, I do believe it, but I also think that when you're a juvenile, I put it in my application, spoke about it, what's so special about that you get to take a look at the whole person. And there's so many other aspects besides just their age or the brain development. There's so many other things that come to mind for me. So when I'm sitting and doing clerk's hearings, I'm always looking to try to figure out who's this person, what are they all about, what kind of supports they have in place. The age doesn't play as much of a role, but I always consider that.
Couldn't you do that with somebody who was 22, just as well as somebody who was 18?
I think I could. I wonder at what point, how do you just keep on going? At what point do you?
I think the studies show its development isn't fully done until the age of 25, 26. So I guess that's where you probably say the minds are fully developed. I think females develop earlier than males. But so to me, we punish somebody who's 21, his mind isn't developed, he makes foolish decisions, or she does, and they end up going to state prison. They end up going to a place where they're probably going to be abused. And it seems to me that we should be a little more kind to those who don't have the developed mind. But anyway, on the issue of crime going up or down, it's my view, from what I read anyway and study, is that the crime rates in the United States have been going down since about 1996, and they haven't really gone up. But I think people think they do because we see a steady diet on news channels of crimes that continually are played in front of us. And crimes sometimes that I listen to and I go, well, Jesus, 30 years ago, this wouldn't even be a news story. It was some local area that was a crime, but it wasn't, all that serious of a crime. And it's getting played throughout the nation on these 24-hour cable channels. People keep watching it and saying, boy, a crime is everywhere. But in truth, from my perspective, this crime really is going down. Less crime is being committed now than ever, less serious crimes too. We hear about people who take a AR-15 and shoot up mass killers. And we, in our minds, say, oh, that's terrible, it must be happening all over the place, but it really isn't. Would you agree with that or no?
I do agree with that.
Yeah. The issue brought up about addictions, it's the latest thing I have read about it is that about 80% or more of people who are now addicted to an opiate became addicted through a prescription that a medical doctor provided. And because of that, even taking it by the directions of the doctor led them to be addicted. And of course, once you're addicted to the opiate pills, it's only a matter of time before you are forced to go to the street heroin and fentanyl. I don't know why any medical doctor in this state, anywhere else for that matter, would ever prescribe opiate, with the exception of somebody who is in the throes of a medical condition that is terminally ill, ever prescribe that poison to anybody, knowing the death and destruction that it has caused in this nation and in our state. Why it is even being allowed to be manufactured is beyond me. And as bad as the opiate, OxyContin addiction that has ravished our country, the pill makers and the drug companies then produce a substance that even is more addictive, fentanyl, and now that is being prescribed by medical doctors. In my view, other than terminally ill, any doctor that prescribes that should have his license taken away from him, because it is taking an oath, the Hippocratic oath, that I will do no harm, and knowing that that can cause somebody to go into the throes of addiction with all of the things that happen to those people. It's beyond me. It's just beyond me. Give you a story about myself. I come from a very long and distinguished line of addicted people. I had a shoulder operation, and when I'm laying in the gurney, when I come to, the doctor gives me a prescription of oxycodone. I said to him, "Why would you give me this?" He said, "For pain." I said, "Okay, but you don't know anything about my background." Well, he said, "You can take it by prescription." So, well, you know, and I know that I might be the type of person that takes one pill. Because of that one pill, I become addicted. He said, "You're right. I should have asked you some questions about your background before I prescribed." Most aren't asking those questions. And they're just as guilty, in my view, of what happened in this country as Big Pharma, Purdue Pharma, that got sued as rightfully they should have. But they had co-partners here. They had doctors dispensing it. They had big companies dispensing it. Somewhere in West Virginia, Walmart, and it's in a town where there was, not 100% accurate on this, but had a population of, let's say, 20 or 25,000. They dispensed like 2 or 3 million of these pills. They knew what they were doing. They did it for money. Doctors know what they're doing. They do it for money. And the more they prescribe, they still get benefits of going on speaking tours that are paid for by drug companies. So I say that to you because it's easy for us to judge those that are heroin addicts or fentanyl addicts. It's easy. There, but for the grace of God, goes anybody in this room. And my sister indicated correctly, nobody wakes up in the morning and says, "I think I'll become a heroin addict today." And there isn't anybody in this room, in my view, that if you were addicted to heroin, you would do anything to get that drug. anything that any other human being did, you would be capable of doing. That's the addictive quality of those drugs. So be kind to those that are addicted. They may have gotten addicted by a doctor they trusted. I think you got great qualifications. You've had a lifetime of dedication to the juvenile court. It's a special court, and I know how much work you have to do as a lawyer in that. It's amazing. It's, as I said, I go there now and then, but I don't like going there only because of the amount of work you got to do. It's incredible. So I appreciate that. I think your witnesses were very good. I think the challenges that you overcome and are still going through makes you the woman you are. And I think you'll be compassionate and kind to those that come before you. You know, any damn fool judge can lock people up, put them in jail or house or in the juvenile detention center. It takes a judge with kindness and compassion to figure out how to treat people and make them better citizens. We'll vote on you next week. Thank you very much. Meeting is over.
I'll call this meeting to order. This is the hearing on the nomination of Mary Beth Ogulewicz to the position of Associate Justice of the District Court. I'll start by reading the governor's letter. Dear counselors, I am pleased to nominate Mary Beth Ogulewicz to the position of Associate Justice of the District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. At this time, anyone who wishes to testify at this hearing, please raise your right hand. I'll swear to tell the truth, the whole truth, and nothing but the truth as it relates to the matter now in hearing before this honorable body. Thank you. We're going to start with Elizabeth Deneen, who is the director of the YMCA, Young Women's Christians Association, for, is it Hamden County? Or welcome. For the record, I've known Attorney Deneen for, I hate to say how many years, but it's close to maybe 40.
Yes, ma'am.
All right. So at this time, I would welcome you and ask you to give your testimony on behalf of Mary Beth Ogulewicz.
Thank you very much. Ladies and gentlemen, as Councilor Hurley has already told you, my name is Elizabeth Deneen. I am a former prosecutor in Hamden County for 27 years. After I left the DA's office, I was the chair of the Criminal Justice Department at Bay Path University. And then the last 6 years, I have been the CEO of the YWCA of Western Mass. While I was a prosecutor, I was the president-elect of the Hamden County Bar Association. And I have known Mary Beth for 31 years. I met Mary Beth when she came to the DA's office as a young prosecutor, and we immediately became very, very good friends. I had an opportunity to observe her as a prosecutor during my tenure at the DA's office, and I can tell you that Mary Beth was one of the best prosecutors I ever dealt with, ever had the privilege of working with. And it's not because of her win-loss record, it's because of her quest for justice. Mary Beth was well respected by every judge that she appeared before, every defense attorney that had an opportunity to oppose her ended up deeply respecting her. And Mary Beth was very well liked in the courts by the judges, by the probation officers, by the court officers, by the clerks. One thing I do distinctly remember about Mary Beth is that nobody in the DA's office was more prepared for her trials. Mary Beth was always open to get information, not only to convict somebody, but more importantly, to make sure that when she got a case, she was convicting the right person. She has the perfect temperament to be a judge. She is kind. She is smart. She is measured in her demeanor. She has great people skills. I also had an opportunity to interact with Mary Beth professionally when she interned at the YWCA of Western Mass. Mary Beth has a degree in social work, and during her last year of her social work degree, she came to the YWCA and worked in our Children Who Witness Violence program, and did an absolutely terrific job counseling children who had experienced domestic violence, sexual assault, or had witnessed it. I can tell you that I think she will be a terrific judge. I think that she is compassionate when need be, and she will be responsible in terms of her sentencing. I think that she is absolutely perfect for a district court position because of her experience in her lifetime. And also because she's been a lawyer and a social worker. So I think in district court, there's always an opportunity for a redemption in terms of somebody who's committed a crime. There's an opportunity for rehabilitation. And I think Mary Beth will work very closely with the probation department and defense attorneys to do that.
Thank you, Attorney Deneen. Any questions?
Thank you for, oh, I'm so sorry.
That was really heartfelt, you know, it's not that this is just a professional, I mean, it just flowed. So, so tell me, what impresses you out of all her attributes that you believe that she'll be a good judge?
Thank you for your compliment and thank you for the question. I think her an understanding. I have seen Mary Beth in many different situations through 31 years. And she's one of those people when you go to speak to about a problem or you ask for advice, she doesn't immediately respond. She's thoughtful. She thinks, she's measured, and she speaks the truth. And I also think that she cares deeply about people. I think that is evident by her pursuing a social work degree. And I think the social work degree will enable her to understand humans better.
Your personal side of it, besides the professional, means a lot to me. Thank you so much.
Thank you very much. I appreciate it.
Thank you.
Thank you.
Excused. Next witness is Naomi Bledsoe of the Northwestern District Attorney's Office. She's the Juvenile Diversion Coordinator. Come forward, please.
Morning, esteemed counselors.
Good morning.
My name is Naomi Bledsoe. I am the Juvenile Diversion Program Specialist at the Northwestern District Attorney's Office and the Juvenile Administrator. With some previous experience working for the Franklin, Hampshire Juvenile Trial Court, and currently I am a candidate for a master's degree in criminal justice and homeland security. It is a privilege to be here today, to speak with you all, and to support the nomination of Attorney Mary Beth Ogulewicz. 1 year ago, I met Attorney Ogulewicz when she courageously stepped into the dual position of the Chief of the Elder Persons and Disabled Unit and Prosecutor in the Juvenile Justice Unit. Over the past year, I've witnessed the positive impact she has made in her office, the trial court, and with our community partners. And I have no doubt that she will continue to do that from the bench. She has managed a very heavy and serious caseload with compassion and good judgment. The juvenile court is a court of rehabilitation. Among the important interests a prosecutor must consider are the interests of the victim, public safety, and the best interests of the youth. I have seen Attorney Ogulewicz carefully consider and advocate for these interests. He strives to tailor every recommendation to achieve a just result. Attorney Ogulewicz is not afraid to ask difficult questions, get to the root of an issue, and fight for what is fair and just. She takes it upon herself to try to understand how systemic racism, mental health, substance use disorders, and poverty may affect those who are court involved. The Commonwealth would greatly benefit having Attorney Ogulewicz as a judge. She is compassionate, dedicated, and an asset to our community. Her background in social work and significant legal experience will serve her well as a district court judge. Thank you for allowing me to testify today, and thank you, Mary Beth, for being an incredible role model and colleague.
And she's also in Superior Court in the DA's office from
The Northwestern DA.
Northwestern DA's office. Yep. Okay, and where were you born, Mary Beth?
Holyoke, Massachusetts.
Holyoke.
To the top.
In any event, any questions? Questions of this witness? Hearing none, thank you very much. At this time, we'll hear from Thomas Wilson Esquire of Dunn and Wilson of Holyoke, Mass, and also previous president of the Bar Association for Hamden County. Thank you.
I have known Mary Beth Ogulewicz for 36 years. We went to law school together. We socialized together. And then when I became a bar advocate, She was the prosecuting attorney in Holyoke District Court. She worked for the DA's office. She was, as was said, very well prepared, very compassionate, and she could be tough. I mean, she has all these kids. She could be tough. And she was very, but she was fair. You never, if she gave you a harsh sentence, there was a reason for that. If she gave you some sort of break, there was a reason for that. She looked at everybody, the victims, the witnesses. She was very, very compassionate, even with the court staff, the probation department, the court officers, the clerk's office, everybody. In fact, it was a sad day in Holyoke when she left. But she was a great prosecutor. She could do a trial. She could cross-examination. She could be tough, as I said. But if you look at her experience, she has a myriad of experience, which now in a district court, I think would be tremendous. She has her mental health abilities. She's done with children who have been in tough situations. She is, the other thing is that Mary Beth is very able to look at a person and understand them and listen to their story, compassionate. Now, that doesn't mean that somebody who does something foul will not go to jail and have a harsh sentence. That's absolutely true. But if there's a need for compassion or a need for be tough, she'll do either side, and she'll look at the case, the people, and everybody else, and people open up to Mary Beth. They always have. I mean, people will just talk to her, and she understands, and she's empathetic. But as far as being a judge, I think now with the way the district court is not, there's more now than just guilty, not guilty, criminal. You have mental health hearings, you have all this other things now, and I don't practice much in district court, but I have sat recently, and I noticed that it's not what it used to be when I first started, and 36 years ago when we first started. But I think Mary Beth Ogulewicz will be one of the finest judges. She will be hearing to her staff. She will be very, 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 very competent in her decisions, should she write them. She knows the law, she writes very well. And I really think that she will be a great addition to the Hampden County District Court, whichever district court she would wind up in. Thank you very much.
Any questions? Councilor Juvenile.
Have you ever seen her lose her temper?
Me? No, I've never seen her lose her temper. I have never seen her lose her
I've been waiting all my life to find a woman that didn't lose her temper. And it took me to come to the council to find a whole bunch of them.
You didn't ask me if I've ever lost it at her, but no, she probably does have a temper, but she's never lost it at me. I mean, she's got her husband here.
You won't ask him.
No, but it's just, she's a very calm person in situations. I've seen her get upset in trials with things, but not lose a temper.
And saw Aaron doing, is he still practicing?
No, he's retired.
You see him, give my best.
I certainly will.
Writing cat here for a lot of years. I can remember shouting at him
Oh, yeah.
in court, not because I was yelling at him, because he couldn't hear what I was saying. Great attorney.
Yes.
Counselor Annie.
Thank you. Could you tell us what particular area in law that she excels?
My opinion that I've really only seen her in the criminal end of law, so I can't comment on anything like that. I know that she's done a lot of work with elderly and with mental health issues, but personally, I've seen her just be a prosecutor. And she was a very, very good prosecutor. She was always very organized. And, you know, that's important, and I didn't bring that out yet. She's very, very organized. And she would have a pad, and she would be able to go down the witnesses, and she would have the, you know, what the elements were and do it. I was always impressed by that. She would have to do it right like that. She was always organized and was very, you know, she would ask the questions directly. And I had seen her once, and I can't remember the reason, but going into somebody's face in a witness stand. But she must have really got, maybe she didn't lose her temper, but she got upset because that person was obviously not.
Why?
You have a long time that you have been a personal friend, and now you've been professionally, you can talk on both, so I appreciate that, your testimony today.
Thank you very much. Is that any
Any other questions? Hearing none, I would declare, is there anyone else here who wishes to speak in favor? All right, no one? Is there anyone here who wishes to speak in opposition? Hearing none, I declare that portion of the hearing over with. And at this time, Attorney Ogulewicz, I would invite you to give your opening statement.
Welcome, and thank you very much, Councillor Hurley. I'd like to begin just by introducing the individuals who are here to support me beyond my witnesses. So I have my family with me, and my daughter Catherine from New York City, my husband Robert Sacco, Ethan Sacco, our son, who's a rising senior in college, and our son Dante Sacco, who arrived here from Cleveland, Ohio. And watching and tuning in, hopefully, is our daughter in Madison, Wisconsin. Along with that, I have my brother Peter and his partner Julia Lynch. And then I also have a wonderful colleague, Berenice Santana. And Berenice was a student of mine in undergraduate. Both Attorney Deneen and I had her as a student. She went to law school. She is now a prosecutor along with me and my colleague in the district attorney's office for the Northwestern District. And I wanted her here today because I hope someday that she will be here. And I wanted her to have something in her vision. So thank you very much.
Thank you.
So it is an honor and a tremendous privilege to be with all of you today. I'd like to begin by thanking Governor Baker and Lieutenant Governor Polito for nominating me for appointment as an Associate Justice to the District Court. I am humbled by my nomination, quite frankly. Through the process of application and judicial vetting, I have met some remarkable individuals who have generously shared their expertise, whom I would like to thank. First, Chief Legal Counsel Robert Ross for some thought-provoking interview questions. Executive Director of the Judicial Nominating Commission, Lauren Green Petrino, for her equanimity and also eloquence. Valerie McCarthy, who graciously accepted my in-hand delivery of 15 copies of my application. Emily Gauthier for her detailed preparatory guidance, and Katie Babin for responding to my hand-wringing questions. I'd also like to thank the Judicial Nominating Commission and the Joint Bar Committee. And thank you, counselors, for your time and your consideration prior to this hearing and the opportunities we've had to meet and discuss issues that were of relevance for you regarding my candidacy. And also special thanks to you, Councillor Hurley, for your guidance and your support throughout this process. I'd also like to thank my family for their enduring support each step of the way, my friends and colleagues who are here with me today, and who made the journey from Western Mass on my behalf to speak. Lastly, I'd also like to thank the courthouse staff in Franklin, Hampshire, and Hampden counties, including the probation office, the clerk's office, and the court officers and security. As you all well know, the process of the administration of justice depends on their collective valued contributions. I thank the staffs of the Hampden and Northwestern District Attorney offices and members of the defense bar who do remarkable work every day. Their zealous advocacy at the bar, lifelong professional friendships, and encouragement through this process have all been gratifying. So who am I? Well, I grew up, first of all, in East Hampton, Massachusetts, which is a small town in Western Massachusetts. My grandparents immigrated from Poland and worked in factories and on the railroad. Hard work, strength of character, and hope dominated their lives and were passed on to me as important values. Both my parents have passed, but my presence here today is a testament to their sacrifice, love, and a belief that they imbued in me that anything is possible if you work hard and care for others. My father left school after the 8th grade to become financially responsible for his family. He dutifully fulfilled the role of the provider for the rest of his life, working 3 jobs while myself and my siblings were growing up and through college. He sold shoes and performed kitchen work and at the log cabin restaurant on weekends and nights, and all of that after working all day in a paper mill in Holyoke. He sorted the complexity of the world with optimism, never seeing barriers. If he were here today, he would simply say, "Of course you could be a judge, Mary Beth. No doubt. No worries." My parents were an indelible part of our family life and helped raise our beautiful 4 children. My mother was a brilliant force of nature, if you had met her. When she began school, she only spoke Polish. So when the bell rang for recess, she left school. She didn't know what was happening. She didn't understand that there was even recess. She repeatedly shared that story over her lifetime with myself and my siblings. My brother Peter, who's here today, he knows that story. Because it was important that she reflect to us that we had a responsibility to look for and care for others who needed help. And that was her message to us. Though not able to attend college in her late 60s, she enrolled at Holyoke Community College, studying every semester up until her death in her 70s. She was a role model for me of lifelong learning. She made a living as a nurse and was exceptional, with prodigious energy and ability to inspire others and pride in her immaculate care of her patients at the Soldiers' Home, Holyoke Hospital, and Providence Hospital. If you knew my mother, you knew the power of fierce love to evoke change and bring out the best in people. And I bear the traits of my parents, I hope. Understanding that one of the most significant factors for resilience is a caring adult, my family that I have with me today has tried to emulate the same care and generosity of my parents, and we have accepted teens into our home who needed support after a family rupture. They needed a home after release from commitment to DYS, help with recovery from substance use addiction, and a home for refugees. If appointed, I would bring that same compassion and understanding, a commitment to learning, and working to assure equitable outcomes for marginalized populations and those who have been historically excluded. With my modest background at age 12, I declared to my best friend that I was going to be a lawyer. My earliest advocacy was in third grade, I believe, where I wrote a letter of protest because only the highest reading group was allowed to do a class play. And though I was in that group, I felt the diminishment of my fellow classmates who weren't allowed. And so I was disciplined at school for that action, and I was encouraged at home. And that sort of set the rest of the course. I attended Boston College, graduating in 1985. The distinguishing features of my college education that remain with me today are the commitment to developing competence in order to do justice in the world, compassion, and to be of service. I learned the value of striving for excellence. Ever to excel is the motto of Boston College. I attended Western New England College School of Law, graduating cum laude in 1989. Upon graduation, I served as a law clerk to the pool of justices in the Superior Court in Hampden County. I was fortunate to work with and be mentored by judges who displayed moderation, humility, thoughtful, nuanced consideration of legal issues, and the impact of their decisions, as well as conversational styles of interacting with litigants. It was then that I decided to engage in trial work for my career and the distant notion that I might be able to make a difference as a judge. I was hired as an assistant district attorney in Hampden County in 1991, and I'm very proud of my public service. In that role, I learned not only how to master trial work and support the voice of victims, but I was determined to be mindful, holding the power of prosecution with equity. I thrive in the setting of a busy district court. I enjoy working with people from all walks of life and building relational trust with victims from diverse cultures under severe time constraints. I worked in the 5 district courts of Hampden County, eventually serving as the head of the Holyoke District Court. I was also appointed the head of the Juvenile Court and was eventually promoted to Superior Court and prosecuted homicides, sexual assaults, and child abuse cases. I have investigated and tried hundreds of cases over my career. I also served for 2 years as a prosecutor in the U.S. territory of Guam, where among my accomplishments, I worked with the local community to create protocols for the investigation and prosecution of domestic violence. By 2008, however, I found myself prosecuting the 3rd generation of some families. And I was troubled by that fact, and it was frustrating that my limited legal knowledge did not equip me to better handle and resolve those issues that brought persons repeatedly before the court. I felt I was missing something. I left prosecution. I taught law courses at a number of local colleges and pursued a master's degree in social work to add to my knowledge. And I graduated in 2018 from Westfield State University with a master's degree in social work. I obtained my clinical social work license, and I am a licensed clinical social worker as well as an attorney. My training includes counseling young adults and members of the community at UMass for trauma, depression, and substance use. I have performed biopsychosocial assessments and developed treatment plans. I also perform clinical work at the YWCA in Springfield, counseling children and their families in the Children Who Witness Violence program, utilizing trauma-focused cognitive behavioral therapy. Given the complex intertwined issues of addiction and mental health that are present in many of the cases in district court, I believe my social work background is a valuable tool for understanding the impact of trauma, individual pathways to treatment and recovery, and the need for integrated care. I use the skills I gained to practice mental health law, engaging in civil practice, including at Morrison Mahoney, where I represented healthcare systems and behavioral health hospitals. I had trials and hearings before the district court, superior court, and probate court, litigating issues of decisional capacity, end of life care, mental health care, psychiatric medication and treatment, and addiction treatment. I have committed time and professionally contributed to anti-racism work, which has been important to me. Working in the town of Amherst, I was the lead staff person assigned to the Alternate Community Responder Program, which was a program researched and promulgated by members of the Black, Indigenous, and persons of color community. There, I learned to listen with as much passion as I wanted to be heard, particularly regarding the impact of systemic racism. In support of that group's pioneering work, I drafted an implementation plan for a grant that secured one of the few DPH grants of $500,000 to fund the launching of that alternate responder program, which will launch within the next month. I served on the court equity team, which developed training for staff and elected officials regarding racial equity, diversity, inclusion, and social justice. I also served as a municipal representative on the statewide Opioid Recovery and Remediation Fund Advisory Council, which was tasked with developing a matrix for awarding funds for opioid treatment across a spectrum of services from education and prevention, risk minimization, and recovery and treatment. I presently work in the Northwestern District Attorney's Office as the Chief of the Elder and Persons with Disabilities Unit, where I investigate cases of abuse and exploitation of elders and persons with disabilities in the District and Superior Court. And I am the Juvenile Justice Prosecutor assigned to Franklin County. Our youth are facing epic rates of behavioral health issues due to unprecedented challenges and missing key developmental milestones during COVID. Those affected youth will soon be emerging adults. And my understanding of adolescent development, brain development, and familiarity with mental health and substance will be useful and helpful to the district court. I believe I can contribute something of merit to the district court. My dual mastery of law and social work and strengths of tenacious problem solving, ingenuity, and a willingness to learn new ways of understanding. I have worked hard to broaden my repertoire of tools and perspective and to build a robust toolbox to meet the evolving demands of the district court and the persons who appear before the court. And I am pleased to respond to any questions you have about my nomination. Thank you for listening.
Thank you very much. I would note that it is almost 10 minutes of 12. We usually break for the assembly. Keep going? Okay. So we'll keep going until otherwise told. Keeping with the rules, I'm going to start with Councilor Juvenile.
Thank you. You've been a prosecutor all your career, about, right?
Yeah, a good portion of it, yes.
A lot of.
Yes. Yep.
How do we know you won't be a prosecutor on the bench?
Because I have a reputation of fairness, because I have the ability, even as a prosecutor, to make charging decisions, to decide not to charge a case. I have null prost cases that have come before me when the evidence did not support those elements. And I think that if you look at the arc of my career, I have tried to garner skill, reflect fairness, wise judgment, and the ability to look at cases and people from multiple perspectives, not just with a prosecutorial lens. And I think my work since returning to the district attorney's office reflects that.
Well, we asked that question just about everybody that comes here that has a lot of prosecutorial background. And they all say what you just said in some form. But a lot of them don't follow through after they get the robe. It seems to change them. You're going to be changed by the robe?
Yeah, I don't think I would be changed by the robe. If anything, I am humbled by that robe. And I have a sworn oath to fidelity to the law. And that includes looking at each case on an individual basis, looking at factors that are also mitigating circumstances. And I think that my background as a social worker, additionally, has highlighted that ability to understand that people end up with legal issues and legal problems, not in isolation. But a lot of times there are social factors that contribute to that. Those factors are important to take into account. So I can only give you a personal assurance. I'm sure that every time you make this decision, there is a certain amount of reflection that you have to take. And I would suggest if you look at the arc of my body of work and the fact that I left prosecution in order to gain more perspective to understand why people were coming before me repeatedly, and that had a desire not to simply incarcerate and do more work without understanding more. I would suggest that that would be.
Do you think district court judges, their duty is to follow the law?
I think it is to interpret and apply the law.
Have been before a lot of district court judges?
Yes.
Had any jury waived trials in front of them?
I have had a number of jury waived trials.
What do you think a defense lawyer uses to be able to make the decision whether or not he or she jury waives?
The reputation of the judge. If a judge is known as a Commonwealth judge or a fair judge.
You would agree with me that there are some judges in the Commonwealth that have never said not guilty in their entire careers?
I would agree that there are some who have that reputation, yes.
And so let's say 2 years from now, after you're on the bench, I'm out in Western Mass and I say to some lawyer that's been around, this judge that we confirmed, I go jury waive, he or she going to say, no way, or yeah, she's fair?
They're going to say, go jury waived. One of the best questions that I was asked during this process was by Chief Legal Counsel Ross. And he asked me, a senior attorney is preparing a junior associate to go before you. And when they hear your name, what will they think? And when they hear my name, the first thing that I want them to associate is fairness, that you will get a fair trial, that you will get a fair hearing, have the capacity to listen to the full exposition of the evidence and to take the facts and circumstances into my consideration, and knowing full well that my responsibility is that the presumption of innocence stays with the defendant unless and until the Commonwealth proves their case beyond a reasonable doubt.
Are you going to have the courage if you so find from the evidence to say not guilty?
It's not even the courage, it's the responsibility to do so.
I think it's courage, because I think a lot of judges don't have that courage. Especially if it's sort of a case that is somewhat publicity-wise, it's getting some attention. I think some of them don't have the courage to say that. I don't know why, they can't be fired for it, right?
Yep.
You could say not guilty in every case you have from now until the time you retire, and you can't be fired. Somebody might transfer you to another court, but that's the best they can do.
I would suggest, I certainly have the courage to find somebody not guilty, if that's what the evidence proves.
So you know judges, and I know them in Western Mass, that I would never jury waive in front. So you know all of them.
Yes.
To me, that's about the saddest legacy a judge could have. Somebody that you would never jury waive in front of. That means they didn't trust you, that you didn't prove yourself to be trustable to decide a case fairly. What an awful legacy to leave the bench with. You were one of those people. So I don't want that to be your legacy.
It will not be.
You've been in jury waived trials where the case is on for trial, and the lawyer makes a decision that day to jury waive, right? There is a court in this Commonwealth that I heard does not allow people to do that. Down in New Bedford, judges there, if you show up for trial, somebody show up for trial, it's marked for trial, and I discussed the case with the DA, we come to a resolution. And we say to the judge, we're here, we're gonna plead. The answer is no, you cannot plead. You ever heard of that?
No, I have not.
You think it's legal?
I would suggest that it's certainly imprudent and in violation of, I know, to be a defendant's right to elect whether they want to have a jury trial, jury-waived trial.
So a judge did that years ago in Marlborough Court, I remember. He had, because of that, he had one of the worst reputations any judge I've ever heard about. And I said to myself, why would you want to do a policy that is probably, if not illegal, certainly not fair, denying a defendant a right to plead? But you've made yourself scorned by everybody on the bar, probably DAs and defense lawyers, because let's face it, you're a judge. I look at it basic. If I'm a judge, I want somebody to plead. It's my day. Right? I don't have to do a jury trial. Get rid of the case. I'm sure both parties go, why would you do that? Why would you stop us from doing it? So I would hope you wouldn't do that.
I would never do that. And I also think that there's another aspect to that, that if an individual is willing to accept accountability, that's an important step for them as well. So I
Well, there
wouldn't
was
somebody.
there was a judge out in Western Mass, he's still there, who, in my view, from what I know, and others, you wouldn't really want a jury waiver from it. But in this particular case, lawyers came and the lawyer for the defense said, Judge, what's on for trial? I want a jury waiver. And the judge said, no. You've got to tell me some reason, and a good reason, why you're going to jury waive it. He said, I don't like that. The defendant has an absolute right to waive the jury whenever he or she sees fit. The judge said, no, you cannot do that. And he made him have a jury trial. Appealed up to the Supreme Court.
That's what
The case?
No, but that's what I was thinking that would be the route.
And it went to the Supreme Court, and the Supreme Court made a finding that judge is completely wrong. That any defendant has a right up until the time that the jury starts getting picked. And the other exception is if there's co-defendants, you both have to jury waive it. Or you both have to jury trial. So you can't split it. But other than that, the defense lawyer has no obligation to tell a judge why he's jury waiving it. Just the simple fact that the defendant asked for it, that's it. You agree with that decision in the Supreme Court?
Yes.
The other issue is that sometimes with these jury and jury waived trials, if a judge makes a defendant, let's say at a pretrial or a C&E date, and he asks, okay, you're gonna ask for a trial. I'm gonna have you waive your right to a trial by jury today if you're gonna do that. And it's been done to me. I started putting it down for a trial, and the judge said, what's it gonna be? Jury waived. I said, well, first of all, I can't make that decision today. And he said, well, I want you to make it. You gotta make it. I said, I can't. Do you think I have to make that decision on that date?
No, not at the pretrial date, no. No.
You know what?
You haven't in all likelihood had the opportunity to fully investigate your case and prepare it for trial, which develops over time, and there may be evidence that would indicate the day of trial that you may choose to elect a jury waived trial versus a jury trial for reasons of your investigation and preparation.
You wouldn't make any lawyer make that decision before knowing who the judge was.
And furthermore, before knowing more fully their case.
I can know my case real fully at the pre-trial, but I'm not gonna be roped into giving up my defendant's right to a jury waived trial or a jury trial that day, because I don't know who's sitting. Right?
Right.
You know that 7 Supreme Judicial Court justices sat in that chair where you're sitting, and every one of them said to us that it would be malpractice, it would be ineffective assistance of counsel to give up that right before you knew what judge was sitting. So I'd ask you not to make anybody give that right up until they knew what judge was sitting. Won't want them to commit malpractice.
Absolutely.
Then what has happened? Well, I won't get into that, but I think you talk very well, and I think you're very professional, and your witnesses were very good. I want to tell you one story. After we spoke, my very close friend in Western Mass in Holyoke, married to my very good friend, was a former nurse.
2-minute warning.
Huh?
2-minute warning.
And, excuse me. And so I asked her if she knew you. And she said she didn't know you, but she knew your mother because she worked for your mother at the Soldiers' Home in Holyoke. He said if your mother had been working there, that tragedy happened. He said, first of all, it wouldn't have happened. That your mother would leave no door closed on behalf of patients. The administrators were in fear of your mother.
It would be true.
Europe. She said she was hard with us, but we loved her because if anybody picked on us, that was it. She'd storm down the hall and open the door and scream at anybody. Leave her nurses alone. So she said that tragedy, in her opinion, would have never been allowed to happen.
I have said the same thing.
So I tell you that story.
Thank you very much for sharing that.
Thank you. Counselor Devaney.
I'm going to preface my remarks, but first I want to say that I'm smiling today. I got a twofer. I'm so thrilled that you went for this position and you earned it the old-fashioned way, okay?
Thank you.
By being qualified, okay, not political. First of all, I met at length with you as I do all nominees. And for the record, I know your position on abortion, okay? But I want it known here that in my 23 years at hearings, I have only asked nominees who are being nominated for the Supreme Judicial Court their position because that's where it applies. The Supreme Judicial Court is the only court in Massachusetts that hears abortion and votes on abortion laws in our legislators. In fact, today, they're taking up to give more access to abortions in the legislature. I have to say this because it's been misrepresented by someone out there and it's gone viral. And I want to say 5 counselors voted for an outstanding woman to go to the Superior Court. She had the qualifications, she had everything. I'm not going to go into it, but she was noted in the legal community. She has been many awards, a super lawyer, top women in law and all of that. And it was very well said. Counselor Juvenile, Counselor Ianella, Counselor Ferrara, and we have a former judge. and they all, and Councilor Ferrara talked about it, that it doesn't apply, so it's not relevant what position it is, because it's only the Supreme Judicial Court. Well, we voted. I want to make that clear, because, like I said, I privately will ask people, but I don't bring it forward only if you're going to the Supreme Judicial Court. That's the court that votes on abortion laws. So having said that, you have an amazing resume. I can't, and I'm so glad you have so much criminal. We need that. We need that in the district court. The thing is that I was amazed at was that you went to Guam. I mean, all this, and I want to hear that, but I want to go back to how do you believe being a social worker will make you a better judge? Tell me about all that experience.
I think it's a reflection of competence and compassion. And the competencies of a social worker are really in line and aligned with the way that we evaluate cases as lawyers. So it gives me a particular lens and perspective around individuals, their background, an understanding of the impact of trauma. If you read the sentencing guidelines for judges, there is an admonishment that we should be considering social science research and taking that into consideration. So my understanding of trauma, of substance use and mental illness is directly relevant to the mitigating circumstances that bring somebody before me. I think it becomes relevant in issues as mundane as a violation of probation, so that you can look at an individual who might be in recovery and who has relapsed, and looking at those questions around how long have they maintained their recovery? Is it lengthening over the period of time? And what were the effective supports that were in place that supported their sobriety, and how can we build more of that? So rather than a reflexive response to violate somebody and incarcerate them, I think I have a more nuanced consideration around that and critical thinking in the way that that would happen. I also believe it would be reflected in my decision-making with regard to sentencing and the ability to tailor sentences that really were individualized. And I'm very well informed around pathways for recovery and treatment, and also mitigating circumstances and mitigating risk of harm for individuals. So I think it's a broad perspective, and it's one that is, I think, particularly tailored to the district court, where we see that upwards to 70 to 80% of the individuals who come before us have co-occurring mental health diagnoses and also substance use disorder.
Well, I have to say, you to me the whole person, because compassion is the one thing I look for. And you're the first one in 23 years when you're asked what are the 4 qualities to be a judge. You said humility, the first one. I've never seen humility ever put in a resume before. I was really amazed by that. But, you know, you have done things outside the court that has touched my heart. I mean, you brought people, young people, into your home from another country, and they've got a high school diploma, all of that you know, adds to it, that I'm voting for the whole person. I like when you talked about how much you learned as a law clerk. I couldn't believe all the things that you had to do with the judges. Now, the one thing that really bothers me with the JNC questionnaire, the rest of the story. And I'm saying, well, what happened? Okay, you've got some really crazy, weird things that you've gone through. Well, one of them, before I say that one, a juvenile accused of sexual assault with history as a victim, mental health evaluation, identified emergent psychiatric issues, and so forth. All right, so you work with counsel to secure treatment, and the outcome will be determined. What's the rest of the story? What was the outcome?
That the individual is currently under psychiatric treatment. And what we typically do within the context of a juvenile court is we secure those supportive services with agreement with the defense counsel. And then we have an opportunity for them to demonstrate the rehabilitation is effective. And when that has run its course of treatment, so it could be anywhere from 6 months to a year, then we would evaluate what would be the sentence. So that we're making sure that we are not tagging somebody with a conviction as a juvenile that would follow them lifelong.
Because we're timed, because I asked too many questions, they've timed us now. This one, I can't even talk about it. A juvenile accused of sexual activity with a dog. Now, how?
Excuse me.
What is the result?
Lieutenant Governor is,
Pardon me?
the Lieutenant Governor is coming in.
Oh, she's coming in. Can I continue afterwards then?
Yes, you have 8 minutes left.
And what?
8 minutes left.
Oh, okay. Okay, I'll talk fast. So something like that, I mean, that's not the usual case. How do you deal with that?
I'm trying to, yes, we're gonna stop. It's okay. It's okay.
Stay.
Order, and I recognize Councilor Juvenile for a prayer and pledge today.
Thank you. Grant us a vision of a world where the weak are protected and none go hungry or poor. A world where the riches of creation are shared and everyone can enjoy them. A world where different races and cultures live in harmony and mutual respect. A world where peace is built on justice and justice is guided by love, kindness, and compassion. Give us the inspiration and courage to build it.
Amen. Amen.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, God, indivisible, with liberty and justice for all.
Okay, I recognize Councilor Ianella for a motion to record advice and consent for the financial warrant.
Thank you so much.
Second.
There's a motion and a second. All in favor, say aye.
Aye.
And I recognize Councilor Duff for a motion to record advice and consent for the pending list of notaries, public, and justices of the peace.
So moved, Governor.
There's a motion and a second. All in favor, say aye. And I recognize Councilor, whose district is this?
Counselor Petito.
Danny, okay. Sorry. For a motion to record advice and consent for the appointment of Christopher and Henry to the position of Associate Justice of the District Court.
Lieutenant Governor, I really went through this and really drilled this man and went over all of his background, very young. And I saw that he didn't have a lot of experience in district attorney. But when I looked at his other administrative work that he has done, he has made some big decisions. He's had hundreds of people that work for him for misconduct or whatever, all of it. But what really came out, I thought, he was in charge. We all remember that horrible Lowell disaster. And he oversaw that whole thing in Lowell. But all of his administration that I saw, I felt that it did apply, that he could make big decisions. He could, be a mentor for other people. And I think what impressed me too was the calls I got from judges. And when you get a call from Judge Frank and Judge Machera, it's something. And Judge White was here too. So putting it all together, I feel that he will be a good judge. As I said, I had apprehensions about his age, but the cases he had in the short time, well over 200 cases and trials, and they said he was outstanding. So with all of that all combined, I'm going to be voting yes, and I'll make that motion.
Second.
There's a motion and a second. Thank you, Councilor Duff.
Just correction of the record. He oversaw very well, I'd like to say, the cleanup of the explosions in Lawrence. It wasn't Lowell.
Lawrence, Andover, North Andover region.
And any other comments?
Second.
So there's a motion and a second. We may commence the roll call.
Council Kennedy,
Yes.
Council DePaulo,
Yes.
Council Hurley,
Yes.
Council Jubenville.
Yes.
Council Devine.
Yes.
Council Iannella.
Yes.
Council Duff.
Yes.
Thank you. We have a new nomination today. Brian J. Costa has been nominated to the position of Clerk Magistrate of the Salem District Court.
August 10th at 11 a.m.
Oh, where is this summer going? Right?
We're gonna be busy.
August 10th, 11 a.m. Okay, thank you. Okay, I know you have a hearing in process. Thank you for all of your hard work all summer long. And that concludes our business today.
All right, everybody come back in, please.
is that throughout my career as a prosecutor, what I tried to demonstrate is that I've dealt with very complex and unique patterns and cases, and everyone is individual. And I think that's how I would approach cases as a judge.
When you look at your career, all of the trials you've had, even, you know, and I want to talk about Guam. What an amazing thing. How did that happen? And Attorney General Guam, tell us about that.
I had an opportunity, I was recruited to go over there. They had a lack of attorneys. And so it was an opportunity to go. We had a contract for approximately 2 years. And it was early in my career. And one of, I think, the fascinating pieces of it was that I was able to do felony work immediately. And also they had significant resources with the federal government. So the quality of sort of prosecution and the kinds of cases that I was able to handle were unique, very different.
So in all your career, is there one or maybe two cases that trials that you've had that'll always be in your mind? Maybe it was because it was so, you know, it was so successful, or maybe it was a disappointment. Can you tell us about those?
There's one case that always stands out when I look back at my time for public service, and that's a case of Kevin Stone. And it was an individual who set a woman on fire. And when I received the case, it was a police report with literally 3 sentences. The police responded, a woman was on fire, and then they sent her through emergency services. She indicated at that time that she was reaching into her medicine cabinet, a bottle of rubbing alcohol fell, and she had a cigarette, and that's what ignited, and that's how she sustained her
I
burn.
remember when we talked about that, and that's what I was just saying earlier too, that these women, I don't know what their problem is, but they will not accuse their, you know, their boyfriend or husband. And that was so ridiculous that having a cigarette and rubbing alcohol would put her on fire. And, but eventually they reunited, didn't they, after all?
Well, what happened was during the course of the prosecution and my investigation, she did continue at some point in time to maintain a relationship, but then eventually did break off. And what I was able to do is to secure the services of an expert witness in domestic violence, because it is important, as you're reflecting, to educate a jury about the cycle of violence and how that impacts somebody. And with the support of that expert witness, as well as fire science through the fire marshal's office, I was able to determine that the flash point for rubbing alcohol was significantly higher, and that cigarette would not be high enough degree temperature in order to ignite rubbing alcohol. So with the physical.
Tell me, when, you know, you're so familiar with the district court, you've had so many trials, so many cases, what do you feel is the weakness in that court? What can be changed?
I think that
what changes you'd like to make if you could.
I think given the volume of cases and the nature of the problems that are presented in the district court, that it's a question around resources. And so one of the things that I frequently hear from in my conversations with the probation department is that case management services, intensive case management, and also community resources in order to get somebody help are really lacking. And we need to robustly advocate for those so that people can actually access the rehabilitation that has been created and crafted as part of a sentence.
Right. So, you know, in all of your, so when you put all together, being social worker and assistant district attorney in Guam, what do you feel all these strengths? These are all strengths to bring to the court, and how are you going to be a better judge with all of those things? What do you think is the most outstanding? Even when you told me you were a law clerk, which you got from that. So what do you think when you look at it all? What do you think stands out that makes you more qualified?
I think I have a unique skill set, first and foremost. So I think that the combination of social work and law is a really dynamic and positive attribute for a judge. Many of the issues that a judge has to deal with in the district court directly relate to those issues of mental illness, mental health, and substance abuse and trauma. And I think that my skill set is really perfectly born for that. And quite honestly, I don't know that I would have applied if I didn't have that extra knowledge for my own personal satisfaction, because I was really stymied by those topics. And I think beyond my unique skill set, quite honestly, again, I think my age and the wisdom and my experience.
But you know, I have to say it again, because I really, I really put myself through a lot when I got someone 38 years old coming before us to be a judge. And I really weigh that heavily. I'm like, you know, look, at 58, you have the age, you have the experience. Life experience is important. You don't have that. And I have seen people when they're 60 and they have been rejected before. And they have said to me, I've heard it over and over, I wasn't ready. And I've learned so much more in the last 10 years or whatever. So I think it has a lot to do with that, the experience you have. And, you know, the pro bono work is something, your community, caring, your personal life, all of that, you know, it has to all, I can't separate the public from the private. You have it, you know, but I just, you know, I can't imagine being Attorney General in Guam. I mean, that's so incredible to me. So, so what do you think? Is there any? Do you think there's any challenge for you when you can't see when you're in court and this could be a first day as a judge?
I think it is a challenge because it will be something new for me, and to be reflective about this. What I do now, I feel masterly, and I know many of the permeations. I have experienced many of the different facets of it, and I have not yet been a judge. So I am hopeful that I have many of the transferable skills and have encountered many of the kinds of fact patterns and issues as a prosecutor and as an attorney. But of course, it is very different when you hold the mantle of being a judge. And I have heard that repeatedly from judges that I've spoken to in this application process, that it's very different to be an advocate as opposed to the judge who's looking at all of the facts and making a decision, as opposed to looking at it from one perspective and advocating for that.
Well,
so that will be
what I found all the time that we spend together. You're a good listener. And I think that is very important for a judge, to be a good listener. And the thing is, you know, I'm just so impressed with your resume because you've had every experience to bring, you know, to the position, and you should feel very confident. And you are humble. And when you said humility for the first value, I said, well, she hit it. So I wish you all good luck. I'm so pleased that you applied and they appointed you. Sometimes,
Thank you, Marilyn.
Sometimes a political person jumps the line, and you didn't, and you don't have any contributions, the whole thing, and thank you. I'm very proud.
Thank you.
Thank you.
Counselor Duff, any questions?
Thank you very much. Enjoyed speaking to you very much, and you do have a good resume, different, which is great. Since you have been appointed to go to our, as we call it, the People's Court, right, the District Court. I talked to you about some of the issues that are very important to me, and I think we were on the same page. I'm not terribly, knowing your background, I'm not terribly worried about how you're going to treat people with different abilities, because you're very familiar with that population, and you also seem to be very, very familiar with the challenges of addiction and the plethora of things that go with that. The issue that I'm concerned about, which seems to be even in this chamber some either misunderstanding or not understanding of how the court system works in this state, is on one's right to choose and autonomy. Now, you as a district court judge, if you were on call, may be called to hear in very low cases. Probably not, but it could happen. You're a younger person, you could ascend to another court, in the Superior Court, where all of those petitions are heard. General law 112-12R says right on it, the petition for, an underage person to have an abortion goes to Superior Court. It doesn't go anywhere else, that's where it goes. And some people in this chamber don't seem to understand that that is a real big Superior Court issue right now, because the US Supreme Court has said there's no such thing as settled law. So, just because one is not in that court doesn't mean one doesn't have to be vigilant and aware of what's happening. You could, President Biden has already appointed or nominated one of our state judges to go to the federal bench. That's where Brett Kavanaugh came from. So we must pay attention to these things. And I need you to tell me you support a woman's right to choose and to have to complete medical autonomy and any autonomy over her own body. Will you say that?
Yes, I would uphold the law that supports a woman's right to choose her bodily autonomy to be respected and her ability to make her reproductive health care choices.
Thank you. And you understand that this, even though you're not being appointed to Superior Court, that these petitions go directly to Superior Court.
Yes. When I was a law clerk, I had experience.
I thought you knew that, but the state's council said Superior Court would never see this, where, in fact, it's quite the opposite. These go to Superior Court all the time. It's frankly disturbing to me that, again, in the chamber, there's not an understanding of how the court system actually works. And this issue is important on a plethora of reasons, and a plethora of claims, not just because you could conceivably go to another in this state, but you could go to the federal. And right now, Massachusetts is a state where we're being protected, where 51% of the population is being treated at least partially equally, right? We don't have equal rights, you know that. Equal Rights Amendment never passed in this country. President Reagan wouldn't sign it. And we are not protected under the law. Women are not protected fully as men are under the law, even in Massachusetts. But it is better here. We know that. It's better here. We're lucky to live here. Our brothers and sisters across the country are looking to us right now for leadership and to protect these rights, because they know, again, pointed to another bench, which could be a federal bench, which could impact them directly. And I want to make sure, I know you understand this, because I know you're extraordinarily, not just smart, you're bright, and there is a difference between the two, in my opinion. I'm not sure a lot of people really get it, really understand how this all works. And I just want to, I just need you to maybe humor me and tell me that if you honestly can say that. I mean, I don't want you to tell me something you don't think is true, but do you concur with what I've said?
If your question is, am I willing to uphold the law that supports a woman's right to choose her bodily autonomy, as well as make reproductive health care choices protected by the law, my answer is yes.
You understand that at some point you could go to a different court if you were nominated?
Correct.
And you so chose?
Yes.
Yes, which could be state or federal?
Correct.
There seems to be a lot of misunderstanding how it actually works, and that is important. It's also important to me to know that you support equal marriage legally and would protect it under the law.
Absolutely. I would uphold the law that protects the right for same-sex marriages.
Even if it fell nationally, would you protect it in Massachusetts?
If that was the law in the Massachusetts, I would absolutely uphold that right.
Okay, because, it's passed to codify it, has passed the House of Representatives in DC right now. We need 10 senators, Republicans. They probably have 5. There were probably 5 more that were going to codify it, but they have not yet found the political courage to come out and say that. I heard Senator Baldwin talking about it this morning. I was actually on a call with her and I'm a member of that community. I was on a call with members of the community from all over the country yesterday talking about this. And I not just because I'm gay, but I'm concerned that Americans don't really understand what's at stake here right now. That democracy is, in my opinion, and others have every right to disagree with me, but it is being held on by a thread. And the US Supreme Court has said there is no such thing as settled law anymore. We're just gonna start over. They're the US Supreme Court. You know, that's how it is. But if you're a minority in something happens to me, my wife could lose every single benefit she has like that. Just because someone decided, because their religion should be separate from what they're doing on the bench, but because their religion tells them that. It's beyond anything I can comprehend. Anyway, thank you very much for your application. I think you're a stellar applicant. You come to us, you know, with accolades from so many people, but you really come with a wonderful demeanor and knowledge of the law. And I think more than that, what your parents gave you, because it shines through. It really does shine through, and it should be, you're a wonderful legacy to your family. So thank you, Madam Chair.
Thank you. Counselor DiPaolo.
Thank you, Counselor. Good afternoon.
Good afternoon.
We had a discussion ahead of your hearing, but I just want to ask about a couple things that haven't come up yet. One is the age of juvenile jurisdiction. If you had policy-making control, do you think it would be wise to change the age of juvenile jurisdiction? And if so, why or why not?
I don't have policy-making decisions as a judge and as
Understood.
the nominee. You know, it's I don't.
If you don't want to answer, what factors would you, how would you approach that question as a potential?
I would approach that question by looking at brain science and development.
And so I imagine you know something about that already.
Correct.
So what kind of evidence would you present to someone who was trying to make a policy decision?
I think some relevant considerations in social science that judges are to take into consideration include brain development and that the fact that we know that adolescence goes through to approximately age 25. I think that the ability to emotionally regulate can be challenging when the adolescent brain is still under development. And that's a consideration I know that a policy group is in fact looking at.
What would be a policy argument if you were to advocate the alternative? What would be a policy argument to maintain the age of 18 as the age of juvenile jurisdiction?
I think when we look at the construct of services within the juvenile court setting versus the probationary and supportive services in the district court, they have been geared and serve different ages and populations and developmental stages. And I think that there is a certain expertise within those bodies and groups, having traditionally handled them with supportive services.
Okay. So the argument could potentially be boiled down to the tradition of what exists, or the infrastructure that's been built around the arbitrary age?
Well, I think it's around expertise.
Yeah.
And handling different age groups. So when you put together an individual who is 11 with someone who may be 19 or 20, that's a significant age gap. And how they present developmentally and socially and behaviorally are very different. And I think it can be a challenge.
In some cases, not so much though, right?
Again,
in many cases, that's not necessarily true, right?
Again, every individual is in fact an individual, but I'm reflecting what's been shared with me from speaking to probation officers within the juvenile justice setting. And
would it be from that perspective, would it be a fair critique to say that the district court is not adequately providing resources or targeting resources or strategizing around the young folks coming through the district court?
That's not been my experience. The emerging adult, who is the 18 to 25-year-old, there's actually specialty courts and some research that's going on with regard to targeting them with special services. So I think that the district court has really harnessed some of the valuable resources to look at that age group and support them in a way that's appropriate.
So there's a valid reason to treat that age group differently around brain development, for example.
Correct. There is a particular way in which somebody develops during those intervening years.
But the support they would need is different than what you think the juvenile court offers?
Yes.
Okay. What are some of the differences in terms of a young person, an emerging adult? What does the juvenile offer that not necessary for the 19 or 20-year-old?
It's not what does it offer that's not necessary. It is that the services and the programs have been tailored to a certain developmental stage, and to extend it to another developmental stage would require almost so wholly separate programs, because you would not want to have those individuals necessarily, those age populations mixing in terms of keeping them together. If it was a residential setting or a placement, a therapeutic placement, what someone who is 22 and 23 is considering and working on in a therapeutic setting or a milieu that would be residential is very different than perhaps an individual who is 12, 13, or 14. And it takes a different skill set and different programs and different services.
Okay. Okay. I don't have any more questions. Thank you.
Thank you very much. Last but not least is me. I think you're going to do a great job. You're very well prepared. And I think that you're absolutely right. The issues surrounding somebody who's a young adult, some of them can be 55 and still be screwed up. But the fact of the matter remains, if they've committed crimes, you can't have the same kids that need help in with the younger crowd in group settings, and even in having the older ones having the ability to influence the younger ones and send them in a wrong direction. And I'm very mindful of that. So I think you can do a great job. I just have one question. Which of your sons is the older?
Oh, the one who's, of course, in the cushiest chair.
Oh,
Each has its privilege. Yeah.
your younger son's name is?
Ethan, and Dante is the older one. Yeah.
Okay, so Ethan, I just want you to know that I practiced before your grandfather, Sacco, and he was just a doll. Everybody, when they went to divorce court, prayed they'd get Rudy for their judge. And I'm sure you're very much proud of everything your grandfather did. What do you think is the number one reason why your mother should be a judge?
Good question.
You still live at home?
This summer I do, yeah. No, I agree with what people have brought up before. I think it's her compassion. Being a mother of 4 children, you definitely learn that skill when one of us messes up or something. I think I see that on a daily basis in both her work and at home.
Thank you. I knew that was what you were going to say because you want to still live at home. At least for the summer. So without further ado, I'm going to declare this hearing over. Vote will be next week, unless there's some delay for reasons that we don't know about now. But it'll be coming up. In the meantime, as I told you, contact the CJAM, okay?
Thank you very much.
Thank you.
Very much, everyone. really appreciate your time and attention.
Clarification.
I'm going to begin by reading into the record a letter from Governor Baker dated June 29th, 2022. Dear councilors, I am pleased to nominate the following person to the position of Associate Justice of the District Court Circuit. I submit this nomination for advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. The nominee is Nicole A. Colby, Longton of Shrewsbury, Massachusetts, to the position of Associate Judge of the District Court Circuit, which position was authorized by Chapter 206 of the Acts of 1988. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker. And with that, we can get right to witnesses who you've brought today, Attorney Longton, on your behalf, and we can start with Judge Eustace, if you like.
Good afternoon.
Thank you for being here.
Andy, Councilor Paulo, Councilor Hurley, Councilor Kennedy, and Councilor Duff. Councilor Juvenile. Almost 5 years ago, you gave me the benefit of your time and ultimately your confidence in confirming me as a district court judge. Every day since, I've done my best to serve in a way reflective of the trust you placed in me. Thank you for giving me that life-changing opportunity. I'll never stop appreciating it. Just as importantly, thank you for the kindness with which you treated me as I went through the process. Like every nominee, I had much weighing on my mind at the time of the nomination. Everyone I knew was pulling for me, including my father, who was at the end stages of a terminal battle with cancer at the time. He told me many times that he was hanging on with the hope he'd live to see his son become a judge. He did. I knew my dad attached some of the measure of his own life to his son's success. And your confirming me wasn't just a gift to me, it was a gift to my dad, too. Your kindness to me during that process abated much of the anxiety I felt at the time, both professionally and at home. Not just for me, but for my entire family. Thank you for the way you treated me in the process. None of you knew me personally when I applied to be a judge, and even as we got to know each other, none of you knew about the health crisis my dad was going through at that exact time. The kindness you gifted me in our in-person meetings and conversations had an immeasurable positive impact without your knowing it. And that's the point I've slowly arrived at. What matters most in life is how we treat our fellow men and women as we go. I've taken the time to talk about this before testifying more specifically about the nominee because I believe this is the best test for those that appear before you in this honorable chamber. This is the best litmus test of how they will exercise the powerful discretion you may choose to vest in them. How have they treated others along the way up until the time of their nomination is the best indicator of how they will serve as a judge in the future. By that standard, confirming Attorney Nicole Longton should be among the easiest decisions I've ever had to make. Attorney Longton is the smartest, hardest working, most capable, and most ethical lawyer I know. But that's not why I'm here today. Because as impressive as her academic and professional credentials are, she's an infinitely better human being than she is a lawyer. I tell you 100 anecdotes to support this premise, but begging your patience, I'd like to share just 2. I'm asked all the time, what's the most memorable case you've had as a judge? And the ones that stay with me usually reveal someone struggling out of sight, out of most eyes, just an anonymous soul acting heroically, trying to get by day to day, like this case. It was a collection case against a single mom making minimum wage with a 5-year-old son stricken with cancer. The least of her worries were her credit card balances. Dismal credit scores don't really rate as a priority when weighed against whether your child will be alive for his next birthday. Her account balance, born from a desperate attempt for financial survival amid the medical bills, was around $6,000 when her account was closed and the credit card company sued her. Might as well have been $6 million for that mom. She had no way to pay it. Judgment for the credit company later entered, the debt then totaling $9,000 with the interest and attorney's fees piled on. When the judgment went unpaid, a second suit via supplementary process aimed at collecting the debt was filed in another judgment, now $12,500 due to more interest and attorney's fees entered. And then a few years later, something that rarely happens occurred. The mom paid the judgment, every cent of the $12,500. She worked extra shifts, she sold her car, she paid the entire judgment. A year passed and she got served with a new notice for a court hearing from that credit card company. The $12,500 she paid was from a judgment 3 years earlier. It didn't account for the statutory interest on the judgment since then or their attorney's fees, and the newest court filing sought another $5,000 from her. A hearing was scheduled. That's when I first got the case. The mom stood alone in the courtroom, her hands worn from worry. An attorney representing the credit card company stood confidently nearby, armed with case law, statutory authority, all supporting his claim for additional costs. I heard both sides and asked just one question. How's your son doing now? Much better, the mom said. Thank God he's doing great. Took the matter under advisement, wanting to take the time to write up a detailed explanation for my decision, and found entirely in her favor. Ordered that the matter be deemed paid in full and that no further collection efforts occur. This wasn't based entirely on empathy. I had some legal authority for it. But none of that is why I'm telling you the story. The story's not about me at all. Later found out that Attorney Longton learned of this mother's story and sought through public filings in the clerk's office her home address. Attorney Longton sent the mom, a stranger she had never met, a large anonymous financial gift with a note attached that read in part, I overheard your story in court and was so impressed. You're a true warrior, an inspiration to me. I hope this gift helps your family. God bless you. She soon thereafter got a written reply relayed back through Amazon from the mother of the sick boy, who wrote back to her, I have no idea who you are or why my situation impacted you as it did, but your gift and kind words mean more to me than words can express. I will pay it forward someday. Thank you. I was the only one that knew that Nicole did this, and I had promised her I'd keep her name a secret. She never wanted any attention for her beautiful gesture. And I hope she'll forgive me today for breaking that promise, because it tells you so much about who she really is. Story 2. Years ago, I began a toy drive in Worcester County when I worked as a bar advocate and matched other bar advocates with children living in homeless shelters across Worcester County. As the holidays approached, directors from each shelter would give me a list of gifts for each kid. I'd then pair them with a bar advocate, making sure that each child got one item from their list. That is until Attorney Longton got involved. After looking at the list, she inquired about how many were ensuring equal value with regard to the requests. Some children were asking for plain white t-shirts while others wanted electronics. Attorney Longton was concerned about how a child with a modest request would feel opening their gift next to a peer receiving something more generous. I explained the limitations of time and money and administrative bandwidth and ensured her the children were always happy to receive any of the items. Attorney Longton was polite but adamant that each child's gifts were to be equalized to the extent possible, even if entire wish lists had to be completed. She insisted that for at least one day, every one of those children who had already experienced so much loss at young ages would not feel any disappointment from a disparity in gifts. I wasn't sure that equity was a possible given the volume of the requests and practical limitations of our volunteers, but Attorney Longton was not dissuaded and offered to personally try to equalize the lists. I vividly recall arriving at the home of her and her husband Steve that year, which we had used as a staging area for the gifts, and I could barely walk through the door based on the mountains of gifts. I soon learned that she had personally bought every gift on every child's wish list to add to the one that a bar advocate had donated. She didn't stop there. She made sure any mothers living in the shelters were given gift cards as well. She wanted them to know that the community supported them in their efforts at recovery. And as if she hadn't taken on enough work as it is, she'd continue calling the shelter directors up until the day of the delivery to see if there were any new arrivals, new residents living there. Because of her empathy and a deep understanding of the struggles of individuals facing housing insecurity, she recognized the likelihood that a mom or a child could appear without warning right up until the day of our delivery. In fact, one year in particular, this happened. A woman arrived in one of the shelters the day we were delivering the toys. She was 9 months pregnant. Seemingly no one at the shelter knew or expected her. And during the gift delivery party, we learned that this expecting mother was in her room, keeping away from the party, too despondent to come out and watch her new housemates open their gifts. What she didn't realize, what I didn't realize, what none of us delivering the gifts realized, is that Nicole Longton knew she was coming because she spoke to the shelter director right up until hours before our delivery. The director told Attorney Longton that this woman was arriving that day, but assured her she wouldn't be expecting anything, and Attorney Longton wouldn't accept that. She went out early that morning before appearing in court on her cases, packed her car with everything from a stroller to a crib to baby clothes. Like every one of the other extra gifts she got the children, she paid for it all herself. The new mom was overjoyed. To me, one of the most amazing parts of the story is that Attorney Longton wasn't there for the gift delivery. She never has been. Every year I ask her to come, every year she refuses to. She eschews any attention or recognition for her efforts. She tells me it's not about her. It's not about seeking praise or attention or recognition from the community. She just wants to help. Now, the older I get, the less I'm sure of. But there's two things I'm sure of as I sit here before you today. This nominee is going to use her seat on the bench to change countless lives for the better. Second thing I'm sure of is when she does, most of us will never hear of it. Her humility wouldn't allow for any attention for it. But the good that I am certain she will do, the justice, the kindness, and the mercy that she will serve with, the lives that she will better, will all trace back to you in this hearing here today. Thank you again for your time and for giving me the opportunity to see all of you again today.
Thank you very much. Counselors have any questions or comments?
Sorry.
I just want to say this was one of my proudest votes in 23 years, and I only hear good things about you, and I wish we could have cloned you.
The luckiest guy in this room, I'm sure of that. Thank you very much, Councilor Devaney.
It means a lot, and it's quite an honor to have him here to represent you. That was beautiful.
Thank you, Councilor.
Thank you.
Judge, I have to tell you, in the 12 years I've been here, that's probably one of the most compelling witness statements I've heard.
Thank you, Councilor. Coming from someone I respect as much as you, that means an awful lot to me. Thank you, Councilor Kennedy, and Councilor Devaney. Saying my respect for you. You know how I feel about you. Thank you for that.
Well said.
And you're a good listener.
Thank you very much.
Does he listen to me?
And is your next witness ready, Courtney? Or Magistrate?
That is a tough act to follow. Good afternoon, counselors. First and foremost, thank you all for giving me the opportunity to speak on Attorney Longton's behalf. It was a little more than a year ago that I was sitting here myself, and it is great to see all of you again. I can also say that a year after your vote, I'm probably even more appreciative of it, as I've enjoyed this past year so immensely. I was honored to be asked to speak on behalf of Attorney Longton and could not be more supportive of her nomination. While I could sit here and go over her impressive resume, I know that you've all had the opportunity to review it yourselves, and I've had many opportunities to speak with her. I think it's more important for me to speak of more of Attorney Longton's character than anything else. I've had the pleasure of knowing Nicole for the past 12 years, both personally and professionally, as an assistant district attorney in Worcester, an assistant clerk magistrate in Superior Court, and now as the clerk magistrate of the Leominster District Court. Nicole has always been someone that I look forward to working with. As an ADA, you never know who is going to be defending the case you were assigned to. Some attorneys you dreaded working with, and others you look forward to. Nicole is always someone I look forward to working with. She was respectful of all the participants, prepared, fair, open to discussion, and even-tempered. With Nicole, you always knew what you were going to get, and that always helped to move the cases forward smoothly and fairly. As an assistant clerk, my experience with Nicole remained the same. She was always prepared, always on time, and always someone that can be counted on to keep the session moving the way it should be. I knew that if Nicole was defending a case, the judge wouldn't be left wanting more from her presentation, could ask any questions that were deemed necessary, and could expect a well-thought-out response in return. She always respected the court and everyone else involved in the case, whether it be the ADA, the witnesses, the court officers, myself, or the judge. In my time as the clerk magistrate, I have continued to see these qualities in Nicole: respectful, always prepared, even-tempered, and a pleasure to have in court. In my 12 years in the courtroom, I've had many interactions with judges, both pleasant and some not as much so. I can wholeheartedly say that Nicole would be a judge that everyone would look forward to working with or appearing before. She will treat everyone with the respect they deserve, always be prepared. She will enter a case open-minded and will preside over a courtroom the way it should be presided over. And as a clerk that still runs a daily session, I know she would be a judge that I would be thrilled to clerk for. I couldn't be more confident in supporting Attorney Longton in her nomination to be an Associate Justice of the District Court, and welcome any questions you may have at this time.
Thank you. Counselors, any questions for the witness?
Thank you.
No. Thank you very much for being here.
Good to see you, Madam Clerk.
To see you.
And I'll also add that we received many letters, and I know from talking to my colleagues, many phone calls on this nominee's behalf as well. So with that, are there any further witnesses here in support of the nominee? Is anyone here in opposition?
Want me to check outside, Paul?
Bring him in. Sorry, I know there's a crew waiting. So with that then, we open it to you if you have a statement you'd like to share. Attorney Longton.
I do, thank you. Good afternoon, counselors. I'm honored and humbled to appear before you as a nominee for the Associate Justice of the District Court. I want to thank the Governor and Lieutenant Governor for their faith in nominating me, Robert Ross and Lauren Green Petrino for all of their support, including Lauren specifically, who was available to me on countless after-hours calls. I thank the JNC and the Joint Bar for their efforts. Apollo, who's represented our district for the last 2 years. We did not know each other prior to my nomination, but he took the time to get to know me as a person and a candidate and support me through this process, and I'm immensely grateful. And I want to thank each of the members of this council, Councilors Ferreira, Ianella, Juvenile, Devaney, Duff, DiPaolo, Kennedy, and Councilor Hurley, who spent time with my application, spoken with me on the phone and in person. I want to thank you all for the work that you do. It's been a privilege and honor to speak to you about my candidacy and my desire to serve the Commonwealth. I'm very incredibly grateful to have this opportunity to earn your support today. And I also want to thank the wonderful friends and colleagues I have here in support of me, my witnesses, Judge Eustace and Clerk Magistrate Courtney Price-Orozco. I hold them both in the highest regard, and their words mean far more to me than I'll ever know. I pause to reaffirm my thanks to God. In my lifetime, I will not cry. I have already been blessed beyond all measure. The first and greatest blessing of my life was being born to my parents, Richard and Michelle Colby, 43 years ago. High school sweethearts, they've been married 48 years. They had my older brother, Richard Jr., and I very young. They did not get to go to college, but they dedicated their entire lives to ensuring my brother and I had every opportunity they did not. My father is one of the smartest men I've ever met. He's never missed a day of work in his life, an incomparable work ethic. My mother, same drive and dedication. She was a stay-at-home mom who devoted her entire life to making sure her family's dream came true. She's the quintessential Italian mother and now grandmother. Growing up, she was the de facto mother to the neighborhood. She fed all of my friends, my teammates, the whole neighborhood. She's now a stay-at-home grandmother, and she is the only reason I'm even here today, and the only reason I've been able to balance my large family with my busy practice. She's loved my children, she's cared for my children, as well as my brother's 4 kids every single day while I work. For my mom and my brother and I are included in this. Her babies have always come first. And as a result of her selfless devotion to us, I've gone to work each day with peace in my heart, knowing my children were absolutely in the best hands. They would be loved and nurtured and treasured. She is the epitome of unconditional love, silent service, and self-sacrifice. And in addition to my parents, I couldn't have asked for a better big brother. He's 3 years older than me. Richard Jr., family is everything to him. He moved across the street from my parents in the home that my parents are still in the same home I grew up in. He moved his wife and 4 kids there because he wanted everyone to grow up together and the same close family support that we had. From the time I could walk, I followed Rich and his friends around the neighborhood doing whatever it took to keep up with them. I insisted on riding a bike long before I probably should have without training wheels. I learned to play every sport and hold my own with older boys twice my size. I would learn to take hits and get back up without even a hint of a tear. And I eventually followed him to Little League, where he had the indignity of being the brother of the only girl in the entire league. playing on the boys' team. Most older brothers would have cringed and discouraged it, but no one was prouder or more supportive. And he offers the same unconditional love and support today, to this day. And speaking of unconditional love, I would like to introduce my husband, Stephen Longton. Steve and I have been together for 22 years. He's a true partner in every sense of the word. His strengths and weaknesses are perfect complements to mine. I'm a classic type A personality. Steve is not. I make lists organizing every aspect of our lives and planning for every possible worst case scenario. He tends to lose the list, but then make me laugh about it. The names our kids' friends call us probably say it the best. I am Mrs. Longton and he is Mr. Fun Guy. Steve and I have come a long way together. When we first met in 2000, I had just graduated college. I was heading to law school. He was young. He was a broke lawyer who was buried in student loans, even though he had worked 2 jobs and went to law school at night. We were together already deep into 6 figures of student loan debt. And I warned him at the outset of that relationship that if he wanted a future with me, there was going to be no unnecessary spending until we were debt free. So my last year of law school, I moved out of my dorm and into his law school bachelor pad. It was a basement level studio in the North End with below market rent. It was also below ground and had no working oven or sunlight. Our kitchen table had 3 legs and a 4th leg that we used to prop up for appearances in case we had a guest, which we never had because we couldn't have possibly fit another person in the apartment. The only new furniture he was able to get in the first 5 years of our marriage was in June when the leases would turn over and he'd get to go shopping from the things our neighbors discarded on the curb. And much to his chagrin, even after I was in the big firm and earning a big firm salary and bonuses, I kept my word and our budget didn't change. So for the next 5 years, we stayed in that tiny basement, chipping away at our loans. And on payday, I would loosen the purse strings long enough to let him get pizza from Regina's. From the outside, I know it doesn't sound like a great time, but the fact is it was an amazing time of our lives, and I wouldn't change those early struggles for anything because they provided a very solid foundation upon which we built our family. Steve and I had a very unique path to building a family. The journey humbled me. It changed me in a way that no other life experience could. No matter what is going on in my life, I still start each day with my heart full of gratitude because there is a time in my life where I prayed for everything I have right now. And I've talked a lot about the support of my husband and my family, but there's one person I didn't talk about yet, for whom I am eternally grateful. My children's biological mother. I'm the mother of 4, but 3 of these children were born to another woman whom we call Mama Kay. And I have my family by the grace of God and because she trusted me with these precious lives. I live each day humbled by her faith in me and dedicated to proving to her that I am worthy of the trust she's placed in me. My children are my dreams come true. They're kind, they're generous, they're compassionate, they're wonderfully unique with their own interests and talents. There's never a dull or quiet moment in our home, and for that reason, my parents are home today with our young sons, Luke and Gianni, watching on the live link, or there would be no dull or quiet moment in this room either. I'm very fortunate, however, to have my girls, Allie, who's 14, and Lily, who's 11, here with me in support. I'm sure it has not been easy on them as I have navigated the challenges of balancing my practice with motherhood. I've joked to them on many days that being a trial lawyer and mom of 4 feels like I'm running on a treadmill in high heels while kids and clients shoot ping pong balls at me. It's been years of getting up before anyone else, going to court, rushing out to pick kids up, get dinner on the table, before homework and sports practices, fielding clients' calls and texts while arranging play dates and signing permission slips, reading police reports and deposition transcripts in the car between practices and orthodontist visits. And then each night after the kids are bathed and fed, I start my 3rd shift researching and writing memoranda of law and returning emails and preparing for trials. I know on most days I got the balance right, but on the days I didn't, I know I did my best, and I hope they know I did it all for them. In my application and in conversations with each of you, I've discussed my education, my training, the breadth of my criminal and civil experience. I've represented clients in every type of matter that's addressed in district court, clients on both sides of cases, both the injured parties, the accused parties. I believe I've thoroughly responded to each of the questions on the application in an effort to demonstrate that I have the legal experience and personal characteristics necessary to be an exceptional district court judge. There are, however, a number of experiences that have not been captured on my resume or application that have been just as impactful in my personal development in judicial philosophy. From high school through law school, I always worked 2 or more jobs. I used my earnings to pay for my car, insurance, and to save money to put towards books and tuition. In high school, I worked for minimum wage at Burger King. I worked the drive-through, I hauled trash, I mopped floors, I cleaned urinals, and it was honestly one of the most important experiences of my life. I met people and saw struggles of people firsthand at 16 years old that enlarged my humanity and impacted my view of the entire world. I met a teenage mom who's my age and was somehow raising her daughter on the same meager paycheck that I could barely stretch to cover car insurance and gas money. A young married woman who was only a few years older than me, but she came into work each day covered in bruises. And to my 16-year-old eyes, I thought her husband was very considerate, dropping her off at the door and faithfully waiting to drive her home after each shift. And it was months before I realized how wrong I was and the abuse she was suffering at his hands. And it was probably years before I truly understood why she felt she had to stay with him. Drew, a 30-year-old man with Down syndrome who came to work every day with a smile on his face and the most incredible outlook and sense of gratitude. I think he was named Employee of the Month. Everyone was there and it wasn't even debatable. None of us came close. To this day, I've never had a better hardworking colleague. After he would clean the parking lot till it was flawless, he'd pick a single dandelion and bring to me to keep with me at the drive-thru. He brought a smile to everyone's face. 25 years later, when I'm faced with significant challenges, I still think of Drew finding a dandelion in a sea of asphalt, and I'm inspired. During the summer, after my daytime shift at Burger King, I'd head to my second job as a waitress. And I always tell my children, everyone needs to work in fast food or wait tables at least once in their lives. Like most waitresses at this job, I worked incredibly hard, relying almost entirely on customers' tips. And many tables were very fair and generous, but more times than I can count, after diligently meeting the needs of a large table, my tip would be nothing more than a handful of change. And a few times it was unceremoniously left in dirty dishes of leftover ice cream. And despite my frustration at working hard and being forced to gather my meager earnings out of trash, I never let it get to me. I laughed it off and reminded myself to be appreciative of the money, even if I had to wash it first. And more importantly, to be appreciative that I was raised to never treat anyone like that. These varied life experiences and lessons helped me develop an extraordinary patience, kindness, empathy, and sense of gratitude. They're part of me, they're woven into my very fabric. If I were fortunate enough to earn your support, I would take these same lessons and experiences to the bench. I recognize that a judgeship is at its essence a position of service to others. It's a position of immense public trust. And I truly believe the most successful judges are the ones who are humbled by this honor. I'm fortunate enough to be confirmed. I will work tirelessly, honor my oath, and conduct myself in the humble and dignified manner that is consistent with the honor a judgeship deserves. Thank you all, and I welcome any questions from you.
Thank you very much. And with that, we can turn to my colleague, Councilor Hurley.
Hello there. I will confess, I had a case with Attorney Longton quite a number of years ago. She was described in one of the letters as someone who was cordial and polite, tenacious when it came to her client's position. Wasn't a big case, but she certainly was someone that I could deal with, as a matter of fact, it was a pleasure dealing with. And unfortunately, a lot of times the folks in Western Mass are not treated as respectfully or kindly as they should be and could be by lawyers from Worcester East. So she was great. And if I'd known in your letterhead, you would put all of these things: super duper lawyer, rising star, top national trailer, top 40 under 40, recognized as one of the top female attorneys in Massachusetts for at least the last 10 years, on and on and on. If you put that on your stationery, I would have been terrified. Well, not really, but it's a pleasure to see someone who has done so well in succeeding in the profession. But I think the better part of your life is your 4 kids and your husband. Obviously, you couldn't do what you do without a great partnership. And mom and dad, as always, play a super part. So Allie, can you stand up for a minute? So you're 14 years old. Yes? What school do you go to? I can't hear you. You'll never be a lawyer like your mother if you don't speak up louder. There you go. So, now this is an important question, Ally. Do you think your mother should be voted on favorably to be a judge? No coaching the witness.
Hesitation.
It's okay, you can answer. You're fine, honey. You might want to turn to Lily. Let's turn to Lily.
Huh?
It's just, you're fine. Help out your sister, sweetie, you're fine. There's a ball.
What do you think? All right, great answer. Okay, I'm sorry, I didn't mean to put you in a bad position. The fact of the matter is, she's gonna have more time to be with you guys. All right? And I think that's probably one of the reasons why she's doing this. But you're lucky to have a great mom and dad. I didn't mean to scare you.
Counselor,
This all the time.
Counselor Ally prefers to put
Guys.
writing. She's a beautiful writer, but she does not like to be put on the spot and will never answer a question.
That's okay.
Directly. She'd rather not answer, but
All
she'll be.
right, so,
But Lily,
thank you. I'm gonna vote for your mom, okay?
there's no question you could ask Lily that she's not confidently going to answer, so they work well together.
Perfect. So I think you're just most importantly, just a great human being.
Thank you.
I have one dog. I've had one dog at a time. I had some stepchildren. Yuck. And for me, taking care of one dog is as much as I could do. That was it. So, thank you very much.
Thank you.
And I intend to vote for you.
Thank you very much.
You bet. Take care.
Counselor Hurley, I'm very sad to hear that Worcester attorneys would treat our brothers and sisters to the West.
Well, that's before I met you.
Any disrespect, but we all need to stick together outside of 495, don't we?
Absolutely. Well, thank you.
Counselor Juvenile, do you have any questions?
I do. I looked at your work that you filed. The case, I gotta ask you, have you ever lost a case?
My first two trials that were second,
Would you put in here you won?
never.
I'm saying, why are you leaving the practice of law? You must be making a fortune. You never lose.
Very well, and I enjoy it, and I have never lost a trial since I've been on my own. My first two trials were in federal court, and they were both losses. I was not the lead attorney, but you know, this person with the CJA appointed criminal case with a full confession to the grand jury.
How many jury trials have you had?
I think total, I don't have the breakdown of jury, I've had more than 30 now.
You've never lost one.
And I can tell you that number would be significantly higher in terms of trials, but I win on a lot of motions to dismiss, 3G motions. I file a lot of motions to suppress.
You must be going before judges that, that's what Kenny and I never get to go before.
Not me, I lose all
It's
the time.
better.
Wow. You ever had any jury weight trials? You decide whether or not you're gonna jury weight it.
Now, and there's certain judges that I would feel very comfortable based on my years of experience in watching other attorneys try cases. I always would select a jury. I did not ever waive a jury for many years in my practice. I changed into waiving jurors. That's not in.
What do you use to decide whether or not you're gonna jury weight it?
If I've seen a judge previously handle a bench trial and I thought that they fairly and accurately law to the facts, I would feel comfortable doing that. But if there are some judges who I've never seen have a bench trial or an acquittal on a bench trial, and I would not feel comfortable giving my client's right to a jury.
Do you ever ask the opinion of other lawyers about judges?
Sure, in the first half of my career, I still occasionally will, but I pretty much know all the judges. Now I'm in Worcester County. If a new judge would come in, that's typical to ask other colleagues, are you familiar with this judge? But as a general rule, I prefer jury and have a comfort level with a judge.
So if you're on the bench, are you going to be a judge that people say they feel comfortable with jury waiving?
Yes.
Because I make the decision based on what I know of a judge and what I hear about a judge. Are judges that in my 43 years, I would never, ever jury waive because they've never said the word not before guilty. Have you ever heard of any of them?
Yes.
So, what kind of a judge, what are we going to say about you after you're on the bench?
I would hope that people say I'm fair and I'm absolutely somebody that you can go jury waive.
My view is that some judges, although they understand the burden of the Commonwealth, they look for everything they can to substantiate a conviction for the Commonwealth. There are other judges with an open mind, look for and hear, look to hear. They would consider some doubt, some reasonable doubt. To me, that makes all the difference in the world as to whether I'm going to jury waive it. So let's assume the case is in your court and it's ready. The parties have picked a date of trial and they show up on that date. And you've got jurors that have come in and they say, we've reached an agreement, we want to tender a plea. You're going to say,
I'll hear the plea.
what about the jurors that were running?
Thank you for your service. I would see if the plea goes through. Just because they're tendering a plea doesn't mean it's a plea that's going to be agreed upon or one that I would be willing to accept. And if it doesn't go through and it's not something that would need another date to be executed, then it still have a jury trial. But if they are intending to tender a plea and it's a reasonable plea, I don't think the fact that jurors appeared means that we need to have a trial. If we can resolve a case for all parties.
Do you think a defendant has a right to plead no matter what stages of the proceedings, except after guilty by a jury? Okay, so even if the jury's been paneled, they're out deliberating, and the parties say, hey, we reached an agreement on a plea, you think a defendant has a right to do that?
I do.
Would do that. Now, in what cases would you not agree if the DA and the defense lawyer, who probably know the case a lot better than you as a judge, tender a plea, under what circumstances would you not accept that plea?
They're not going to know more about the case than I do, because if they're putting up a plea and they want me to accept it, I need to know the relevant facts about the case. If there's a disparity between what I think is appropriate and what the parties are suggesting, I would need some explanation for that, whether I need a sentencing memorandum or documentation for what they're requesting. Otherwise, I would think it would be, again, conceive of a situation where I would be so wildly different in terms of an outcome than both the Commonwealth and the defense counsel.
You think you would know the case comes into your court for anything, and the parties are going to plead. You would know more about the case than the DA, who's had the case probably for 6 months or a year, and the defense lawyer who's had the case for a year.
I would know as much as I need to know on plea. So when I know from my practice, when I'm putting up a plea and it's disparate, or it's something that at first glance a judge is not going, there's a sentencing memorandum, there's full documentation. I'm not saying, he wants to get into counseling, judge, and that's why my recommendation is no jail, even though he's in counseling, and here's a letter from his counselor, and here's a letter from his psychiatrist. Everything is well documented. So if the parties are at a conclusion for a specific plea, I would think if all parties are, I'm probably going to find it to be a reasonable disposition. If I'm not, it's because I'm missing that information, and I would ask counsel to provide it to me. Tell me why I accept this plea.
And that's what they do. You hear from the Commonwealth, they state what they expect the case to be and what they can prove. And then you hear from both parties on sentencing, right?
Sometimes they're in agreement and sometimes they're disparate. And if they're disparate, I would expect it to be explained as to why they're taking such different views of this position.
But you hear from the lawyers, right? So the defense lawyer would have a different than the DA, and the DA has their opinion, and the defense lawyer has theirs. And you would make the call, right? A little unusual, isn't it, to ask for a sentencing memorandum in the district court?
I don't think it's unusual. I think it's, as an attorney.
I've never had one in 43 years.
I've never.
Superior Court, sometimes.
I've never put in an unagreed plea without one, and often I do one ahead of time to speak with the Commonwealth if I anticipate that it's going to be a disparate. For example, if it's a significant substance abuse issue or a mental health issue, I always do that ahead of time. I'm not going to require every attorney, and I would never expect the court to require that in every case, but there are some cases that are so significant, or there's extenuating circumstances or a background really needs to be told to justify why you're making a certain request. And I find that it's very helpful to the court. It's certainly helpful, I think, and it's worth an investment of time, because judges have said it to me over and over again. You know, when I first looked at the record and I first looked at the chart, I didn't know what you were asking. Now that I've stepped it back, looked at the sentencing memo, I understand. Same with the Commonwealth, that would have firmly be in a position of this is a jail. And then after looking at a suggested sentencing memo, coming to an agreement. And oftentimes those end up as agreed dispositions or very, very close together in terms of those resolutions.
Do you think things in district court are that serious that you've got to have them produce a sentencing memorandum and you're going to have to come back again for another day to argue the plea?
I've never had to separate it out and have it on another day. I don't know if maybe the sentencing memorandum can be as simple as a few pages outlining the bio, background.
Couldn't I tell you that as a lawyer?
But I like to see documentation. I like for the court to see documentation and for the Commonwealth to know it. It's not a.
Why did the documentation mean anything other than what the lawyer told you?
Sometimes the lawyer's repeating what a client tells them, and I would like to verify. So I don't want the.
So if my client tells me something and I argue that in my plea, you're going to say I want a memorandum, and I'm going to take a memorandum, and I'm going to sit there and I'm going to write the exact same thing that I just told you because that's what my client told me. So how are you going to? What are you going to do with that to know whether or not it sounds like you're not going to believe it? So you want something in writing so you can believe it.
Well, I would say to the attorney, okay, you say that the client's in counseling. Tell me about that. How often does he go? How long has he been going? How many times?
And I tell you that.
You're an officer of the court. I mean, I understand that, but I'm telling you.
You're going to say, well, I'm on a memorandum now. I want it in writing.
Just to be clear, that's my practice, and I'm not saying there's any bright line rule. I just found it's very effective, and it has been very helpful to the judges I've spoken with. That they appreciate it. It's certainly not in every case, but it is something.
I'm going to predict that probably 99% of the lawyers that practice in the district court, where most of the cases are cases that end up in some probation programs, and probably a very small percentage end up in somebody going to jail. Would you agree with that?
Overall percentage in district court, I mean, I think more often than not, yes. It's probation, other disposition form.
I mean, rarely does somebody go to jail in the district court. I'll bet you it's not more than 10%, if that. And it's usually a mandatory, something like a third offense OUI or a fourth offense OUI. But other than that, the great majority of people end up taking a suspended house sentence, and even that isn't done very much anymore, and probation with conditions. I guess I don't see the need of, just because you did it, that you're gonna make all the other lawyers do these sentencing memorandums.
I didn't say I would make them do it. I just said that's been my practice. And I would expect that if an attorney is standing before me, they're an officer of the court, they're telling me the truth. But I do prefer to have documentation. I don't back away from that. If
They can't give you documentation.
a client completes a program, I would.
I'm gonna tell you that. So you're gonna say, I don't really believe you, Juvenile. I'd like to see it in writing, and I'd like to see documentation that your argument is actually truthful.
Well, I think we do that. You see that in the probation department. There's a reason we have probationers sign release to confirm that probationers are attending a program and completing a
But
program.
they usually haven't started them yet. They haven't been found guilty, or they haven't pleaded yet.
So if we're asking the court to give a certain disposition because this defendant has done so much and has completed a program I would think the same level of diligence. And again, it's not a bright line rule that if you were to appear in a court, you need to do this. I was simply explaining my preference, which I've been told is different than what a lot of people do in district court. But I do find it's been helpful, and I don't take the view that it's just district court. So is it really that serious? Because it may be not the most serious case I've ever had on my desk, or certainly not the most serious case you've ever had on your desk, but to each individual client and to the victims on that case, that is the most serious thing on their desk. So I always try to give it the same level of attention, because that's the only case that matters to them. And I would put myself in their shoes, whether for all of the parties. And in the vast majority of different district court cases that I've had where there's been a true victim, a lot of times it's a family relationship, whether it's a domestic or parent-child. A lot of them are very gratified and affirmed to see programs being completed, to see that. And unfortunately, with cases like with substance abuse, with things where there has been a pattern of someone maybe letting down family members, lying to support a habit, things like that, to have them say, oh, the lawyer said he did a program, but I don't. I honestly think that has helped from personal anecdotes or stories in so many cases to know it's a verified fact. It's not his defense lawyer saying it's true. He really did complete the program. He really did sign up for the marriage.
I get it. You're not gonna believe the lawyer.
That's not it.
Why else would you want documentation?
I'm an officer of the court, has an ethical obligation.
So I'm an officer of the court. I'm telling you that that's what my client's done. And you're saying, I don't care whether you're an officer of the court, I want documentation of it. Right?
I would prefer documentation. I'm certainly not going to take a position that anyone.
Let me ask you this hypothetical. Person's on probation for heroin abuse. And 2 months after they're on probation, the order is to refrain from heroin. And the person is violated by probation because they have a relapse. And the probation officer wants them to go into the house of correction. That's the only facts. Didn't commit a new crime, didn't do anything other than violate. Put them in jail. 2 months later, they're back again, they relapse again. Probation officer says, hey, this is the second time, Judge, I want them to go to jail.
No, part of recovery is there are relapses. I would like to.
The fifth time, he's violated. Nothing else, no new arrest, no new nothing, violated. To another 2 months, he violates. Fifth time, the probation officer says, Judge, this is the fifth time. I want him to go to the house of correction.
I don't see what the house of corrections is going to do. He hasn't committed.
What's your answer? Are you going to send him to the house of correction or not?
I'm not inclined to send him on that. I would ask for what has he been doing? Are there programs? Is he being supported? Is there an alternative to, is he just gripping his seat, hoping to stay clean, or is he doing something? Probation, there can be supports, there are programs that can help. And if he's not availing himself of those or he's not aware of them, I think the court can help with that. He doesn't need to be.
Well, that's going off the field. First of all, I'll go by a side. So probation doesn't, just one more, probation doesn't supervise anymore, in my view. I love probation, my daughter's in it. They do not supervise anymore. The supervision for the $65 is peeing into a cup. And The fallback for some probation officers, oh, they violated, they should go to jail. They don't understand addiction. So I like the fact you wouldn't, I think you said you wouldn't put them in even a 5th time, but you're hesitant about that.
I would need to know what he's doing. I mean, I
He
think.
failed, he relapsed.
What's he doing for?
Nothing, he did nothing, he relapsed.
I would probably order a program or something to support him. I don't think jail's the last resort. If he's out committing crimes, different.
I'm going to interrupt you. In my view, jail is not the answer ever on an addiction. Any judge that puts somebody in jail on the sole purpose is, the only reason is they relapse, does not understand addictions, and shouldn't be sitting on a bench. You don't give him any credit for the 2 months he went clean, which is an unbelievable thing for a heroin addict to do. And, all right, I'll leave it like that. Thanks.
Counselor Devaney?
Thank you for all the time you afforded me. I really appreciate it. I really got to know you. I meet with everyone because I'm not just phoning with someone on this paper. I want to know the whole person. And I have to tell you, I can't think of anyone who doesn't have compassion. If I won't look at it, doesn't have compassion and empathy, and you do. And I'm in love with a grandmother. I wouldn't have said it in front of you to others, but your life is amazing. It really is. So thank you. When 2 children came home and 4. I mean, that is truly amazing. Now, how old are the boys now?
They're 8 and 6.
Yeah. So everything is well. Yeah. Yeah. I have 4. They didn't all get together. My son didn't like his brother, I think, till he was 12 years old. So you're doing well.
They get along very well, but there are moments.
But just remarkable. And you know, your pro bono is amazing. And we don't see that. Most of them say, oh, I don't have time for pro bono, I can't, or my job doesn't allow it, or whatever. Amazing. And you have gone that extra mile for people and kept in touch with them and some horrendous cases. Tell me about the award-winning coach who was 35-year-old plus, and she was openly gay. She had gone through a lot of harassment. That was quite a thing. What is that, the Title IX?
That was a Title IX case. So she was an openly gay coach in the 90s. And at a university she was the victim of some significant homophobic attacks. Had a strong suspicion of who it was. There was an investigation at that time. They just sort of swept everything under the rug. Fast forward 20 years, the Me Too came out, and there was an anonymous letter that she was this perpetrator of an attack going way back, and referenced decades earlier. So from the outset, it looked to me this continuation of this attack, but the way it was handled.
Right, it was all anonymous.
So what was unfortunate, she was immediately removed, banished from the campus without a word. No opportunity, was a gag order, couldn't speak to anybody while they investigated this. And the way they investigated it was pretty horrific. They asked very leading, loaded questions about her. Did you ever see this? Did you ever see this? So her reputation was destroyed in that period of time. I can tell you that after a year and a half, we had the final hearing. She had retained, back when email was new, she had printed emails. This never would have happened, but she had files. But what happened was after they investigated the Me Too Anonymous, they couldn't find anyone. No one ever saw anything. No one ever did anything. And then finally a woman came forward, a young woman, and said, I had a consensual relationship with her. It was inappropriate. And she kind of took it forward. And what it turned out was this young woman had significant mental health issues at the time, had kind of relied on the coach for a lot. And it was all documented in emails that the coach had taken her to the counselor, had done everything, went above and beyond. And she was 20 years later. She was off campus for a full year and a half. She was fully vindicated after a hearing, reinstated, and then was able to retire.
And you said that this Title IX hearings drove you to be a judge. You really think that?
seeing how those are handled, seeing how those investigations are handled. Seeing what it means for being a truly fair, neutral arbiter absolutely is what I would love. I loved balancing those cases with being able to go to court and actually appear in front of a judge, because you didn't have that in Title IX. The same people investigating the case were deciding the case on the merits and were circling the wagons around themselves. And had a very much a feel of a witch hunt.
Something about the Raymond Rivera case, that was, I can't believe it. I mean, they even found babies in the closet. I mean, I can't believe that I don't know how you went home and slept at night having these cases. God bless you.
That was a very difficult case. It received a lot of news attention because of he was not charged with anything related to the deceased.
Excuse me, could we stop the cell phones? Just be polite.
Babies,
I'm sorry.
the fetuses, he wasn't charged with that. He was alleged to have been the biological father of 2 children in the home that he was reportedly unaware of. He had 2 children that he knew of, and there were 2 younger babies that his wife had told him she was babysitting. And that case went on for years. I did submit a writing sample on that, and it was ultimately resolved.
I mean, things were dismissed. What actually, was it guilty of anything? Was there any sentence for this person? You know what it is? I've always said it. I don't know the rest of the story of the JNC, and it's so, oh my God, what happened after that?
He was held, he was on a very high bail. He was held during that period of time. He was convicted on, I don't remember the precise charges, but I know the charges that were dismissed were the ones that were the subject of that writing sample, which was, he was biologically the father, but at the time he didn't know. So really the issue was, if the statute requires you to be a parent in order to have criminal liability, if you don't know you're a parent, could you truly be criminally liable for not protecting this child that you're unaware of? Is there a duty there? So that argument was unsuccessful in a motion to dismiss, but it was ultimately part of the plea agreement. It was.
I really love to have someone with and their solo practice. I think it's different the way I see it. If you just work solely as a district attorney's office or the attorney general, you give him the client. You choose who you're going to represent. And not only that, the police give you reports, so you're halfway there. So, and the other thing, you're responsible for shoveling the snow and for the rent and all of that. And I think that makes you more a concern and more compassionate when people come in and they have a lawyer and you know what they're charging the lawyer and everything. And you've done so much pro bono work. I haven't seen like this. It's remarkable. And all I can think of is you're a young woman starting law practice. You're sitting there waiting for people to come in. I'd be petrified. It's an amazing thing what you've done, what you've accomplished, and the awards that you had gone. I'll get into that. But you had a wonderful. It was really. It had a good, not starting right, but it had a good ending about the client that you had coming from the streets of Puerto Rico. That was beautiful.
He's doing really well, actually. He has this will be his 3rd child, but his 2nd baby in a few years on his way on with his wife. So he grew up he was on the streets of Puerto Rico from a very young age, in and out of the system, pulled a very big sentence, and spent basically from 18 to, I want to say, late 20s in prison, and then ultimately, I believe, ended up in the House of Corrections for a stint. I mean, within weeks. He had no time as an adult as part of society, no support for family. He had a child who he had fathered, I believe, right before he went in on the long bid. He got out, had nothing, nowhere to go. He was living in an abandoned Yukon and bathing in Bell Pond. And he used to survive just day labor jobs. And I was introduced to him because I had helped a woman pro bono who was the victim of domestic violence, and through her employer. In any event, this young man was working day labor and was working so hard He ended up getting a real job with a local employer who helped him completely turn his life around. What wasn't clear is that this young man wasn't on his record of drug use, but he had a substance abuse issue. And when he came out with all the trauma he had experienced, he was back on and off drugs. And probation, to their credit, recognized it, got him into programs or tried, and then COVID hit, and there weren't beds, and there weren't. So he ended up having some driving charges that were fairly significant, and he was going to be held. And I did a sentencing memorandum, and I did everything to try to get him out. And Judge Richardonian Superior Court said, "You've done tremendous advocacy. Get him a bed in the next 24 hours, and I'll look at it." And the bed we found one in New Hampshire, which is my first choice program. It's called the Plymouth House. It's an excellent program, but it was expensive. And his employer said, "I'm going to pay for it. This is the hardest working guy I've had. He would do anything, and I'm going to support him." And he went in, he did the program. It was 30 days. He did the step down program. He got out, he paid off all of his, he couldn't get his license back because of all the fees and fines. There's just so many obstacles when you're released. He got everything back. The woman who also works for this employer, they fell in love, they got married. He reconnected with his teenage son. He's a father for the first time, getting to be a father, fully paid up on his child support. And he and his wife now have one baby and one on the way. And he went so far from bathing in Bell Pond to now, they have a nice, lovely home, taking care of their children. And his substance abuse issue, that program worked miracles for him. We got him into outpatient care, so he constantly has that counseling support.
Just meeting with you for a long time and looking at your questionnaire and you have influenced so many people in their lives. And this young man has kept in touch with you, and that must be so rewarding to you.
Truthfully, it's through his wife. He's a man of few words, but she sends me, when they had their first baby, I sent him a blanket with the months, and I get a picture every month with the...
Tell me about this. You established women in the area. Tell me about that.
So Women in the Arena, when I
Arena.
When I opened my office, there was one female judge. There were very few criminal defense attorneys who were female. There were very few there were very few defense attorneys who were female. There were a number of ADAs. Was very fortunate to have wonderful mentors, but they were all pretty much older men. So as my practice really developed and I realized there were women who wanted to do what I did, but didn't know how or didn't have the confidence, I actively looked for ways to help. And one of the things was to just be more honest about, hey, this is what you need to do. It's going to be hard, it's difficult, but let's support each other. And I got a few other experienced attorneys who were willing to give of their time and their resources, female, and we've built, it's very informal. I'm also the co-chair of the Women's Bar Association for the Worcester County Bar Association. So I see the benefits of the Bar Association. What this offers is a very informal way to quickly have resources and to have that support. And I just had this awful experience where I have this client, what can I do? Where I really want to go out on my own, but I don't understand things like malpractice insurance or rent. And it's a way to do all of that. I find that it's been extremely helpful to some of the younger considering it, just to bounce ideas off of, and it's been great to meet.
But said your answer why you want to be a judge, because you said your life's purpose is to help people, and you've done it. I just can't imagine how many people are out there that you represented that are still in touch with you, and you've changed their lives. If you hadn't been part of their lives, where would they be? But I do want to recognize that you have been recognized as Massachusetts Rising Star, super lawyer for criminal defense, 10 years in a row. That was amazing. And recognized by Boston Magazine as one of the top female attorneys in Massachusetts for each of the last 10 years. And recognized as a national trial lawyer, top 40 under 40. This is an amazing thing. You've had, how many trials?
Before I applied, I counted, and then I've had some since. It's more than 30 at this point.
Well, you know what? And I still can't get over it. 4 years ago, we had someone to the Superior Court, he had 6 cases in 21 years in Superior Court, and he went to Superior Court. Yeah, I could write a book. The political people can jump their line. I'm glad you got through. And it's remarkable, really, because we need more people like you. We need to clone you. So,
Council, one
anyway,
minute before we go to council.
I'm timed for 15 minutes. You know why? Because when we were taking this vote to make it 15 minutes between you and me, someone said, one of the councilors said, there's one councilor that asks all the questions and there's no questions left. There's a million questions out there. I don't understand that. But I want people to know how qualified you are. You know, I mean, this is not a political appointment, and I just couldn't be more pleased. And tell me, how many people interviewed you from the JNC? How many were there? There's 21 lawyers that have the responsibility to choose you to recommend to the governor.
10 were on the Zoom screen and 1 present. It was 9 or 10 on the.
So the total was what?
It's 10 or 11.
Thanks. What I'm so
Thank you,
angry.
Councilor.
In this administration, there's never been more than 12 out of 21, and they all vote. Thank God you got through.
Thank you.
They're going to time me, because they want to go to the next one, and I thank you, and I thank you for all the time you've given me. I really enjoyed it.
Council Duff.
Thank you for your patience. Thank you. You're a stellar candidate. I don't need to beat a dead horse. Folks who reached out to me about you were people that I have the ultimate respect for. The conversations that you and I had, I'm not going to rehash here. All of us spend a lot of time vetting the candidates in different, some of us meet, some of us talk, but every single one of us does the same due diligence. I don't need to rehash your resume or your cases with you. I feel very confident that you will do an outstanding job on the board. So I have no questions. Thank you, Mr. Chairman.
Thank you, Councilor. Councilor Kennedy?
Ask you a question. Those 30 trials that you did, was that over the whole 20 years you've been out there?
So my first 6 years, I was in a big firm, and
I saw that, Will McDermott.
2 of those were, I was second seat, and there were a few trials there where I was, if there is a phrase, I was 12th seat. So I didn't count those. I wrote, and then after that, those were just trials where I was on my own.
So what?
So since 2009.
What's your average caseload?
About 100 a year.
You do sentencing memorandum on all 100 of them?
Well, that includes personal injury, number 1, and number 2, no. It would definitely just be the cases where there's going to be a problematic disposition or disparate, significantly disparate.
I just want to clarify that, because I wasn't that clear when I was asking the question. Because right now, I've got about 200 cases, partially because of the pandemic. It would be impossible to do sentencing memorandum on.
It would be unnecessary if you have a very simple plea where all parties are on them. But I believe I was responding to him saying if the two parties were at a disposition and you're not there, well, obviously I'm missing something. If 2 experienced counselor at the same point, why wouldn't I be there? So throw it to me. What am I missing? Or tell me. But that anytime a judge is going to look at me and say, why are you asking me to do this? I anticipate it.
I just wanted to give you a chance to clarify that, because I'm not sure that really came out, that you don't have an expectation on every plea that people are going to be doing sentencing memorandums.
I don't think, no, because a lot of times they are stepped back, and you can't step back 100 cases a day.
I didn't think that's what you intended to convey, and I wanted to give you a chance to clear that up. Now, the second thing, I just want to say one thing, and I'm not going to ask you any more questions. Lighten up. You've been working for 22 years to get here. You're here, okay? You don't need the level of intensity that you've been going at. You can burn out pretty fast in this job. And every day that you go into court, I have one request of you, and I've made this of many other judges. Start the morning with a smile and good morning. It makes a difference, setting the tone. We've all been there. You go into a court and, you get a pleasant judge like, I was going to say Judge Eustace, but I'll go with Judge Mehta. You go into court, there's a nice smile and good morning. Let's get to work. What are we going to do today? It sets the tone. It really does. And that's what I expect from you, to set a tone that starts with pleasantries every day and it goes throughout the day. Okay. I think, one thing that I think you learned how to do is count at some point. Okay, you were counting as we were going, right? I assume? Votes?
I wouldn't be so presumptuous as to count a vote. I'm gonna wait.
Well, it sounded to me like you have them. Said, thank you, Mr. Chair.
Thank you, Councilor Kennedy. Attorney Longton, we had a great conversation or two coming into here. I don't have a lot of litmus tests, but I know from your opening that you lived in the North End. So is it Regina or Ernesto's? I heard Regina brought up, but I didn't really heard Ernesto's mentioned, so I didn't know.
It's a point of contention early on. I was from Regina, but I believe my husband availed himself of Ernesto's for many years prior to my stringent budget cuts being imposed.
Wrong again.
All right, under advisement. We heard some great testimony, by the way, from your witnesses. That was very heartfelt and persuasive. I wanted to ask you something that we talked about, and I hope you don't mind me asking. I'm a dad, and I'm a very active dad, and it's a challenge to juggle things. I'm not a mom. Are there unique challenges to someone who's put together the professional resume that you have to being a mom, to working in the courthouse and doing this work? Are there barriers in that?
I think when I opened up, I experienced barriers in the sense that it's so helpful when you're trying something that's challenging and going out of your comfort zone to see someone else who's doing it and to see someone who's succeeding. And I looked around and I remember there was Judge Guzman, who's now appointed to the federal bench. She was the private female defense lawyer she was the only one I met. And I remember her words to me right before she was nominated. I had no idea she had applied. And she said, "It's so nice to see a young female defense lawyer who's driven coming up behind me, because you do all of this work and you're turning around and you want to help the next person. It's so nice to see you." And I was picturing that she would be someone I could reach out to, and then she was a judge within probably just a couple months. But I was cognizant of that and mindful of that at a certain point I became one of the attorneys that other young women, whether they were DAs or from big firms or just wanting to open up, that were reaching out to me, or judges were putting them in touch with me. And I realized that I could help, because it was intimidating. I looked around for the model of success for the pathway and I didn't see it, and I had to create my own. And I did have wonderful mentors, but there are unique challenges that any working mom could experience. And there was, I learned how to deal with them. Maybe I didn't handle them the best, but I find that having a lot of people share their experiences has been extremely helpful to the women coming up.
Yeah, one of the reasons I feel so great about your nomination is I really believe that you're going to get in there and you're going to build a legacy of bringing people along with you. And I just see that in your work ethic and in your approach to things. I just wanted you to just briefly hit on why, strike that. You mentioned a couple programs that you've utilized for clients, or clients have utilized in the past. We talked about incarceration as a last resort, or as a means of protecting public safety, and I'm taking a pragmatic approach to that. Is it important, in your estimation as a practicing attorney, that a district court judge would be familiar with the resources, the treatment, the programs, the diversion programs, the transitional services, the housing? Is it important that a district judge have kind of a localized feel for what's out there, for the resources that are there?
I think it's very important that they have that information. I think that you can develop that, but I think it's very helpful when somebody comes to the bench already aware of those things and then learns the details of the local programs and the local players who can connect them.
I know from today's hearing that you are very, you're very familiar with the impact that trauma has on people. What is the impact that trauma has on someone's development?
I think there's the scientific evidence, which is clear that it affects things like risk-taking and impulse control, and their ability to do what they need to do to be successful. There are barriers, and a lot of times it's unseen, and that's the problem, is it's invisible, and it might manifest itself in crime. So I think that's something that's a judge needs to be familiar with, sensitive to, and if not familiar with, become familiar with, because it's going to be part, everyone that stands before you may have a story, but the invisible trauma, that's really something that they have to be in tune to and aware that could be driving a lot of the issues.
Okay. And so when we're taking into account brain development in our juvenile court, and the SJC says that we need to, that's appropriate. But when we know brain development is still continuing past the age of juvenile jurisdiction, how do we circle that square? To what extent is age and the childhood trauma, if it's there, that exacerbates the development, to what extent is it informing you as a judge in crafting dispositions or sentencing decisions?
I mean, I think I look at the age, I look at first and foremost, what does this individual, whether it's a child or a young adult, need to get back on the path to success? And if you're familiar with, or you become aware of the trauma and the background, and you take steps to make sure that that's being treated, I don't particularly care if that's a juvenile court issue or a district court issue. At the end of the day, is they're getting the treatment. But
is there room in your practice as a potential district court judge to inquire about potential childhood trauma?
I don't think that it would be appropriate for the judge to ask that, but I would certainly expect counsel to have, a defense attorney to have. I can tell you again, my practice, when I have an individual come in, even somebody who reports no mental health issues, I strongly encourage them, and by strongly encourage, I mean, I basically have my assistant makes the appointments to get a mental health counselor.
Does every defense attorney have the wherewithal or the motivation or the initiative to do that? Because I doubt it, right?
PCS has a wonderful social worker. There are resources, and it's up to the attorneys to do it. I certainly wouldn't require it. I mean, sometimes someone's there for childhood trauma. Sometimes someone's there because he's made a bad decision and they led a very blessed life until that point. We're going to be judged the rest of life.
Here's my last question for you. When I walk into the Worcester courthouse, what are the people working there going to tell me about you?
I would hope that I can tell this council, I've received different outpouring of support I mean, text messages and calls. I couldn't believe the level of support and how far it had traveled. The news and people, I'm praying for you, and I was receiving texts with these great well wishes that I would like to think that is exactly what we're here, because it's people from all walks of life, from all throughout the court. When clients began finding out, I mean, it did spread pretty quickly that I had been nominated, and even when the due diligence process was going on, received words of support, but in the past few weeks, it's just been an incredible outpouring from pretty much all the courts in Worcester County.
I'm really confident I'm going to be proud of this yes vote that I make on you. I've been really impressed talking, especially actually talking with people in the bar community, besides just talking to yourself. Your reputation is very real and your work ethic is through the roof. And I hope that you do find that balance, like Councillor Duff was talking. And actually maybe it was Councillor Kennedy put it a little more bluntly, but I'm really excited at the possibility of you sitting on the bench. So unless there's other comments or questions, we will adjourn this hearing.